appropriate direction.
I would pardon to mention
Next.
the petitioner is actually assailing rehabilitation assistance scheme since 2013. So he has tried different forums and is pending since 2023. Yes.
Termination matter process already completed. It has not distant finally fixed date.
Pardon to make a mention, my lord. State level scrutiny committee cancelled the my lord yes, my lords. Tomorrow, my lord, state level scrutiny committee cancelled the certificate. My lord, on 23. My lord, his medical registration to be cancelled. There is a notice.
Pardon to mention, my lord, due to non-regularization of the leave period, the petitioner is not getting pension.
Pardon to mention, my lord.
My lord?
Pension you are not.
Yes.
Next. Pardon to mention, my lord. The petitioner is not being allowed by opposite partner to perform his duties in spite of order from opposite partner.
My lord, this is very urgent matter. Transfer of government employee. No, this is it will take him today.
Why it is already disposed of. Similar 27 matters.
Well, you will get the it's not here.
There are 27 matters listed. No, it has already registered. Today it has come up.
There's a registry.
Okay. But
in the meanwhile, inform your.
they have all consented.
Yes.
Well, it's item number 28 and 29 of the third list.
29.
Yes. First list, page number 3. Senior counsel J.K. Rath is leading this matter, my lords. He is medically unfit, as an outcome of which I pray for an adjournment. No.
See.
Page 3, 15 to 24.
Grateful.
Page 4, 25 to.
You're standing.
Well, it's I am repeating state. That is why I am mad.
Item 1.
Your Lordship may kindly see order dated 9/8/2000. But the pensionary benefits were not paid. He is not getting the. He was made to retire on 17/7/2015. Yes, he was given compulsory retirement. With effect from 17/7/2015. And that is why it order dated, your Lordship may kindly say annex. Hello?
Other than constitutional authority, all they will retire on the last day of the month.
Yes. Your Lordship may kindly see annexer 11, page 36. Page 36 at page 37, Your Lordship. He is allowed compulsory retirement from service with effect from 17/7/2015.
They are to remain absent.
Absent. And till date, they are not paying my pension and pensionary benefit. And your Lordship, last they have from getting instruction from the authority.
How many years of service?
Have
you put in pensionable service?
Yes. That they have admitted. Yes.
Where are they?
Your Lordship may kindly, that is why I am placing your Lordship.
Why, brother? Why you are?
My lords, kindly.
Case of compulsory retirement.
My lords, kindly see.
No, I am asking.
Why?
1 second. Is it a case of compulsory retirement or dismissal?
Compulsory
Retirement. Then you have to pay all.
My lords, we admit. My lords, kindly see. Flag why? My lords.
Like why?
My lords. Letter dated 13/5/2025.
Now, what it says? Tell us the gist of this letter.
My
Let me
lords,
read.
he is not cooperating, he is not signing the papers. That is why,
Ask which papers to be.
my lords.
Bring those papers tomorrow to the court. I'll get him signed.
That is why, your lordship, for a moment, your
We
lordship.
will give you pension. Or you want argument? No. Then what? Ask your client to be present tomorrow. Ask your officer along with the papers to come to court. Over.
That was the order passed.
Why are you wasting time?
My lords,
In fact,
they
you are not supposed to waste the time of the
My
court.
lords, only play day.
No, yeah, all. Yeah. The government advocates opposes the petition, contending that they are ready to give sanction and give sanction and pay pension, provided the petitioner puts the signatures, which he is refusing to. First, counsel for the petitioner is agreeable that he will ask his client to be present on a day after tomorrow to put the signatures after seeing.
No, everything has.
One more set you have. What will you do? Do you charge for his signature? No, one more signature. Yes,
No,
sir, yeah.
everything.
Let's waste our time. Next.
For a lordship.
First, next. Don't waste our time.
Yes.
All small matter.
May I please, your lordship?
Yes.
My lord, the petitioner.
Ask your officer to bring all the papers to court. He will put his signature here itself. No. Yes.
Here I have challenged the rejection order under Annex 4. And the background of the case is the petitioners are the teaching and non-teaching staff of an aided college. The college was notified to receive block grant as per the grantinate order of 2008, read with Section 3B of the Orissa Education Act. My lord,
What is your grievance? First,
the grievance is we filed a writ petition earlier claiming for retirement benefit as per the Retirement Benefit Rules 1981. Then
who should pay that retirement benefit?
state government.
That's all.
State government. Then the GPF benefit under the GPF Rules 1983.
They are not paying that.
Yes, and
Slowly.
Yes.
Just because I want to know.
they are not paying. They are not
paying.
They are not paying.
Why are you not paying?
Well, because they are. The reason is since the college was notified to receive block grant from the state government, they say that the rules which are meant for aided educational institutions that will not be applicable to you. Only
Repeat. They say.
Yes.
Complete the sentence. I have started your sentence.
But they say that since these employees initially got the block grant as per the granting order of 2008, not full grant, so therefore they are not covered under those rules and they are not entitled to get the benefit under those rules. My lord,
What is the law on the point?
the law on the point is, your lordship may kindly see Section 3B of the Orissa Education Act 1969. Which defines aided educational institution.
In this page number?
But page number 115.
You have to take the file of page number also.
Page number 115.
Okay, flash there. Kindly read.
Yes, well, your lordship may have.
Kindly read. I have memory.
Aided educational institution means private educational institution which is eligible to and is receiving grantinate from the state government. This is one part, and includes an educational institution which has been notified by the state government to receive grantinate.
Once again, you mean to say the institution cannot be classified as those receiving block grant
and full grant. Full grant.
That difference does not admit in the scheme of debt.
Yes. There is a judgment of this Honorable Court in Ritanjali Giri's case, wherein it has been categorically held and that judgment was not challenged in any higher forum.
It has attained finality.
Yes, and that has already implemented. Your lordship may kindly see that judgment. Of course, that is relating to rehabilitation assistance scheme.
But this question is decided.
This question is
in which paragraph it is decided?
Paragraph 7. Your lordship may kindly come to page
7. Use the statute.
7 and 8. Yes. Section 3B of Orissa Education Act.
No, may not be necessary. You have already read it. 8. Go to 8.
8. Then Your Lordship,
They notify the state government which
On a value-
in A
Yes.
is an aided education act, does not make any distinction between the full grant and block. What do you say, brother?
Yes.
That's the only point. Any other
Yes,
point?
yes, that is the only point.
What do you say, brother?
And my lord, so far as the rules is concerned, 81 retirement benefit rules, the only rider is that the institution must be under the direct payment system.
Direct payment system. What is that?
Your Lordship will kindly see. Kindly see the 81 rules.
No, what is meant by direct payment?
Direct payment system, my lord, where the grant is disbursed directly to the employees of that institution.
Oh.
And under the 2008 grant in aid order, my lord, because we received the block grant for grant in aid order of 2008. The grant in aid order of 2008 clearly postulates that grant in aid will be disbursed directly to the employees. Your
Not to
Lordship,
the institution.
not to the institution. Your Lordship, kindly see the grant in aid order of 2008. That is at page 443 of that book. Because
One second. Well, just I'll have clarification from you.
yes,
Do you agree with the proposition of law which he has canvassed based upon the judgment of a coordinate bench of this court? Do you agree?
My lords, kindly,
No, I'm asking a question to you. Pure question of law.
my lord, we say that that is not applicable to
Not applicable. But proposition you agree.
this.
Like one second.
And another thing, my lords, this is impugned order is of 17/5/2021.
The recurring
4 years. 4 years.
Recurring
Yes,
project.
not challenged it. Delay and latches also comes to.
Where have you stated in your objection
So
statement?
it is first time has come.
First time.
first time has come.
Sorry, I do not understand your listing system. It is bit different from ours.
Yes, Your Lordship, may kindly come to ruling.
Welcome to. I am issuing notice.
Yes.
You want to still argue?
Yes, yes.
Issue emergent notice. Learned AGA.
My lords,
AGA Shri.
Behura, Behura, Behura.
Learned AGA. Behuda is requested to accept notice for official response. All official respondents.
Yes, yes.
Official respondent.
Governing body.
Since a very small point appears
Yes.
to be involved in the case, call it week of minutes.
First. So far as opposite party number 6 governing body is concerned, I will take notice by speed post.
Issue emergent notice to the
OP number 6.
OP number 6, which is a private site. First, requisites to be furnished, something like
Item-
that in your work. Yeah.
Item number 7 is also similar.
Identical
Identical.
in item number 7 also. Same respondent.
The same respondent. Same respondent.
Share copy of this judgment with your friend.
Yes, yes, yes.
Take
Here, my lord, there is no governing body. In the second case, there is no governing body, only state respondents.
You want to say? Issue. Most immediately offer service.
In the second case, item number 7, there is no governing body, so only state
Only
respondents.
official response.
Yes.
9 years, 8 years girl child, and 11 years son, my lord, and his
Grandchild.
my lord.
Grandchild and grandson also.
No. Son 11 years and 8 years daughter, my lord.
Taking direction for transfer.
But any representation they have given, you have
Yes,
to
yes.
take a call.
Yes, yes.
You have taken. Where is your representation?
My lord, Annexure 6, my lord.
Annexure C.
6, my lord.
Page 17.
Right now. The short grievance of the petitioner is as to non-consideration of her representation dated. Where is the date for this?
My lord, 5/11/2000.
5/11/2024, a copy whereof avails at Annexure 6. First, essentially, in that representation, a request is made seeking her transfer based upon the family difficulties. First, the counsel for the petitioner submits that whenever a representation is made seeking placement, the employer has to consider it within a reasonable time in view of decision of the apex court in Varadara versus State of Karnataka. And that having not happened, this court should make a rejection. First. Next paragraph. Learned AG appearing for the respondents, banking upon the same decision, opposes the petition, saying that no employee has a right to seek transfer as such. First up. However, he agrees with the suggestion of this court that in terms of Article 350 of the Constitution of India, he would instruct his clients to consider the subject representation in accordance with law and send an endorsement to the petitioner within an outer limit of 3 weeks. 3 weeks. First, all contentions are kept open. In view of the above, petition is disposed of. First, if compliance is not reported within the said period to the Registrar General of this court, strong, stringent contempt action may follow. Cost may be easy.
Right.
Item 4.
My lord, this is a claim of pension and other pending dues of her husband, my lord. And as the husband is a mentally retarded person, as per Annexure 4, my lord. And this case has been posted today for instruction from the opposite party, my lord.
What do you say, brother?
My lords, I have
Husband has gone senile and therefore she is seeking some relief. What is your answer?
My lords, I have received the instruction, your lordship, from 2005. The person has not reported, my lords, after serving for 5 years.
Only 5 years. But what action you took? He did not report for due. It's a misconduct. What action you have taken? We will file a statement of objections.
My lords.
Counter?
We will file counter.
Counter to be filed within 3 days, failing which right to file one stands forfeited.
My lords, little more time.
Within 1 week. Therefore, I asked which is the rule. Within what period you should file the counter. You cannot, these are all constitutional reliefs. You can't just say we will not file the counter for this. If you do not want to file, tell it that we will not file. We'll say that you don't want to file.
Let me take instruction, my lords.
But within 1 week, failing which the right to file one stands forfeited. Yes, next.
Item 6.
6. Yes, brother.
Here also. To my the school wings miller, my prayer is that page 12. Page 12. I am also the employee of the block grant, the school miller. My prayer is that the employee they have to treat the petitioner at par with that of the page 12 miller.
Pay scale. Grievances to pay scale.
First case.
Your complaint is about the pay scale.
But the question is that one judgment already passed by your lordship. This court. I have annexed that judgment. My employees of the school wings mailer. To direct the opinion one to take immediate step to treat the petitioner at par with that of the employee of the.
He should be treated as an employee of aided institution. On what ground?
Block grant of school mailer. Item
serial number 1 or 2.
See the college wings, it is a school wings.
That's the
in the school wings, this one already passed the judgment.
Saying that they should be treated as
to pay,
one sentence. You are not very clear.
Yes.
Your sentences are broken. You said there is a judgment to treat. I am asking you to treat as the employees of the aided institution.
Block grant. Aided but block grant. Block grant order 2004.
Oh. Issue emergent notice. Learned EGA is requested to accept notice for the official respondents. Whether the institution is party?
No, my lord.
No, institution is not a party.
Call this matter. Which date we have put that? Those matters? 2 matters we have pushed. Call this matter along with mention one of this one, so that one order will dispose of 3 cases.
I will serve the copy.
Serve the copy. Requisites to be given. Petitioner to serve copies of the petition along with all the documents on the learned EGA right now. Yes.
All right.
Next.
Item 8.
Kindly be brief. Be articulate. I will grant you relief. Do not waste your time. Do not waste our public time on it. Okay. Next.
Item 8.
May I please your lordship, my lord?
Yes.
My lord, the petitioner, the student of the school who appeared in the exam June 24. In the meantime, 1 year has been passed. Their result has not been published. It has catapulted. It has catapulated.
On what ground?
Just we are approaching the information given by them there. Due to some technical snag, it has been delayed.
Or for 1 year?
Last
technical snag, 1 year delay.
That is your lordship. Last time the Hon'Ble Court directed to take instruction.
Who appears for the respondents?
I appear for the university. The instructions that I have received that they have published the result in the month of February, but the details I have not gone through. So
you'll give it tomorrow.
Pardon?
Give it tomorrow.
Yes, ma'am.
Call this matter tomorrow.
Yeah.
At the request of panel counsel appearing for the respondent. First, urgency is because of the fate of a student whose results have been, examination results have not been declared for a year. But this is unusual. Yes. Next.
Item 9.
Sir,
Yes.
it is a claim of differential amount of area of UGC scalar pay, my lord. They are calculated erroneously and disputed by the opposite party, my lord. So it has been passed by your lordship.
Mr. Are you in Delhi? Which place you are?
Which is by this
Liar. Are you outstation liar?
Passed order.
What is this?
Well, it's a prayer for granting UGC scales and area places.
The teacher has retired from the employment. Because the benefits are given to others.
Retirement.
Because she says that benefit is given to other teachers.
Yes.
Then how can you deny that to this?
Well, it's the first time it has come.
Issue emergent notice. Since the teachers, retired teachers are grieving against the non-grant of a particular pay scale on parity basis. First of all, learned DGA on request accepts notice for
1 and 2.
1 and 2.
3 notice will go, my lords.
Emergent notice to the rest. Refugees to be furnished in normative way. Within how many days they should furnish the refugees? 3-4 days. Rules are not there. Within 3 days, we can say. Yes.
Item 10.
All are similar matters, my lord.
Same order. Follow along with. Next.
Item 11.
Similar matter, my lord.
Same order. Call along with.
12 also same.
12 also.
Yeah, man.
Okay. 11 is different.
12 is same, man.
11?
11 same.
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 Item 13.
Bunch these matters. Bunch all these matters so that they are posted on the same ticket.
Item 13.
May I please,
Let's see.
last occasion, this one could directed to the State Council to take instruction 13. Text.
1-3. Your turn is yet to come. Kindly be seen. Yes, we take up that also. Yes.
Last occasion, this one could directed the State Council to take instruction the position of appeal filed by me.
My lords,
Under the Education Act.
And under the punishment against the punishment order imposed on a teacher.
my
So
lords,
that is before the tribunal
limited prayer is that
to dispose of the
appeal. Your lordship may.
Okay. The short grievance of the
One fact I developed, I said, the director appellate authority issued notice fixing today is the hearing of the appeal.
I'll make that order also. The short grievance of a teacher who has suffered an order of penalty in a disciplinary proceeding is as to long pendency of his or her. Why do you not write Srimati, Mrs. etc. Nothing. You can't treat them as if you are servants.
Srimati Nalin Patel.
You have to write that. Otherwise, how we should know the gender? All names are both gender neutral in your state. Yes. Take that. That's right. He is against long pendency of her statutory appeal under the provisions of which act? Orissa Education Act.
No, OCS Control Act. OCS CCA rules.
OCS CCA rules. Education. Learned counsel for the petitioner submits that the right to speedy justice being a facet of Article 21 of the Constitution of India, her appeal cannot be kept pending eternal. Next paragraph. Learned government advocate appearing for the official respondents initially opposed the petition and now agrees with the suggestion, graciously agrees with the suggestion of this court that he should instruct his client to dispose of the appeal within an outer limit of
3 weeks.
4 weeks. 4 weeks. And report compliance to the Registrar General of this court. 4 weeks, let it come here. Dispose of and report it to Registrar General, failing which personal appearance of the concerned officer may be ordered. All contentions are kept open for being urged in the appeal. No cost. Now, no cost. Next time, heavy cost will be imposed.
Item 14.
14. Yes, sir.
My lord, it is an identical question and a bunch of cases are today listed before your lordship.
Which is that?
My lord's lead case is 43137.
Serial number.
With it has come with second item.
Serial number.
WPC.
We should notice in this matter.
My lord,
Yes.
we have filed counter.
Yes, ready for disposal.
My lord, identical question I will please.
Cancelled.
Yes. Whether.
But he wants to take that cancel. Therefore, he argued that. He wants to consult his clients and come back.
And so stay operation, my lord, stay operation in my case is required. As because
No, all cases.
All cases ready for
It is
disposal.
granted in other matters.
what they are doing,
We're asking a question.
my lord.
Whether interim order is granted in either a similar matters with the other judges. No.
No, that is why I am. Interim order may carry.
Last token.
My lords, we have
Everything is filed, case is.
Just a minute. Satpathy, and we have given affidavit saying so that we will not, in which the Honorable Court has asked, we have submitted affidavit and on the basis of which it to be disposed of. The matter relates to registration of marriage and matrimonial marriages.
My lords, in one matter we have filed counter.
That we will adopt in rest of the matters.
My lords, we'll adopt that. I pray 2-3 days time so that we
Call this
can.
matter on Thursday at the request of Learned AGA. Finally, on that day, very short point.
Well, that day I had some fun, probably next week or anything.
Until then, no coercive action may be taken in my case, my lord. No coercive action may be taken. They are going to revoke all these things.
On that day, if they do not do, we will consider your prayer. Maybe,
My lord.
maybe little leniently.
Very interesting case, my lord.
My lord, it is an interesting case. A statutory provision cannot be, by way of statute, cannot be overruled. That is the whole gamut of the case, my lord.
Okay. Well, call this matter along with serial number 2.
My lords, all the matters.
All these matters.
My lord.
Serial number.
Item 14.
Item 15.
Along with so next week.
Next to any date, date.
It will come because we do not know what are dates fixed for me by the other coordinate bench. Therefore, for that reason, I say. Next week it will come. If it does not come, just move it.
Coming Monday.
Monday or Tuesday?
I have answered your question. You cannot go on asking the question again and again. Yes.
Item 15.
Yes. Yes, Mr. Monty, what is this matter?
This is in respect of the appointment of Shiksha Sahayak.
Shiksha Sahayak.
Shiksha Sahayak. In the meantime, though he has been overaged, but however relied upon a judgment, of course, that has neither it has been referred to nor it has been annexed. The petitioner is not there, so he
Can we-
pay for a passover, by that it will be easier.
Passover. Or the notice is yet to be issued.
Or notice we should.
Issue notice, learned AG is on request accept the notice for.
For my lord, opposite point number 1, 2, mana all my lord.
For the official response, all official respondents. Call week after next.
2 weeks after.
Call after 2 weeks. Section 16.
Yes, my lord. Here, this is second round litigation, my lord. Earlier, this petitioner filed a petition before this honorable court, and this honorable court directed the opposite party to consider his case in the light of Dhananjaya Charanade versus State of Orissa.
What is
But,
that?
my lord, in that case, my lord, the petitioner is working as Gana Shikshaka, and he availed the benefit of Shiksha Sahaka with effect from 2008, my lord. Because the Gana Shikshaka are on train and the Shiksha Sahaka were appointed at train qualification, my lord. Here, my lord, this Gana Shikshaka is training qualification before appointment, my lord. Therefore, he is
obtained it after appointment.
after appointment. But here, my lord, this Gana Shikshaka appointed obtain training qualification before appointment, my lord. 2000.
Covered by judgment.
My lord, covered by this judgment.
Mr. Monti, is it covered by the judgment?
Let them supply the same because
The copy of that.
My lord, judgment is here, my
Yeah, why 2 copies are here? Repetition copy to be signed, but satisfied. Nothing like that. Is I have other matter.
I have served copy.
You have served copy. Mr. Monti, learned AG on request accepts notice for the official respondents. Or any other private respondent?
No private respondent. No private respondent, my lord.
Because I cannot find out easily because keep on turning the pages. Okay, call after 3 weeks. Because second round litigation.
yes, please. I'll take the instruction whether it will be.
After 3 weeks, since it is a second round litigation. Okay.
Item 17.
Mr. Monti, I have a small request to make to you. Wherever you have received notice, petition copy you have got, ask your officials to be very vigilant. If they comply with the order, whichever they have made, if possible, for example, disposal of the appeal, they have to dispose of the appeal.
Let that not be kept pending for
Cannot be.
days together.
Wherever there is a reasonable delay, ask your officer to wake up and address grievances of the petitioners. And pendency will not come in the way. You can simply file a memo saying that matter has become infectious because we have already taken the decision.
Now we'll do the note.
Pendency will.
Today it is in the heading of all face admissions, in fact.
No, this is only a request. Yeah.
Item 17.
Here is a case, let's see, the only small pair, the
Correction of the name
of the
of
mother of the child, the petition, mother of, and the present petitioner's name has wrongly mentioned the school
Electoral school certificate.
School certificate. In my daughter.
Your daughter is aged what?
Class 9.
9 class. Minor child. Are there rules for change of names in the official records in the educational institutions?
When
in Karnataka, there are such rules. Change of name rules 1968.
When the my child has not attended the board, so it can be changed in school level.
Whether a school is a government school?
Yes, sir.
What do you say, Mr. Monti? You can take a call.
This is a very Divya Jyoti. That spelling was they are to be corrected. Of course, 10th pass, then board will be the authority.
For school, there is no problem at all. The short grievance of the petitioner is as to non-rectification of name of his ward. Her. See, you do not write Srimati Shri. This is my problem. You don't respect women in this state. Her ward. What is name of the ward? Child.
Divya Jyoti.
Divya. Tell the
DIBYA.
DIBYA.
JYOTI.
I see. Kumari Divya Jyoti.
Das. DASH.
Right down.
But it has been reflected as Jyoti in respect of JYOTY, JOTI. That is the.
That's it. I'm not copying in this. There is not there. Only I'm praying the name of the mother of the child. Yes,
the short grievance of the petitioner is as to non-inclusion of name of petitioner's husband, who happens to be the father of the child Kumari Divya Jyoti, in the school records. First, learned counsel for the petitioner submits that there is no legal impediment for entering the name of the father of the child in the school records, and introducing of the said name would create in future problems relating to higher education and job as well. First off, next paragraph. Learned AGA Mr. Mohanty, on request appearing for the official respondent, submits that if the petitioner cooperates, there would be no much difficulty in addressing the grievance of the petitioner in a time-bound way and in accordance with law. First, in the above circumstances, the petition is disposed of, directing which school?
Government Gas High School at Banki.
Which is the respondent?
Respondent number 3.
The third respondent to effect necessary changes in the school records by mentioning name of child's father.
Child's mother.
Mother. Child's mother.
Yes.
Mother. Child's mother. Mother. There is one judgment of Madras High Court which said name of the mother should be reflected in the official records. Can anybody? Where is our researcher? Where are you? You should keep track of what is happening in the court hall. Take out that Madras judgment. Name of the mother to be entered in the school records. Come. Within a period of 3 weeks.
Let it be 4 weeks, because on 8th they have to communicate it to the BO and all.
All think within 4 weeks. Within 4 weeks. First, 4 weeks. And report to the Registrar General of this court within 4 weeks this week. That 4 weeks put afterwards. Telling which it is open to the petitioner to seek revival of the petition for levy of heavy costs on the officials concerned, personally payable by them.
Item 18.
Petitioner was engaged as peon in the 1990. 1990.
Peon.
On DLR basis.
On?
Daily wages basis.
Daily wages.
Earlier he had approached this Honorable Court, and this Honorable Court directed to regularize the service of the petitioner.
Directed consideration or regularization? Consideration.
I have quoted the order at page 4. May I read my order?
Not necessary. I believe you.
Thereafter, when they have not considered, once again approach this Honorable Court. This Honorable Court directed for regularization of the service.
Regulation only. Not
consideration. Order.
Not consideration.
No, my lord.
Where is that order?
Annexure page 5, Annexure 5, page 29 is the relevant portion.
The order. For this board of directing the opposite parties to comply the aforesaid true direction by its letter and spirit, and should not show any laxity in taking steps for compliance of the there shall be. Mr. Mohanty, take notice. Keep that official present before the court, unless you comply with the orders.
Well, they have complied. What happened thereafter? They have extended temporary status. After this order of this Honorable Court, they have extended temporary status. Thereafter, regularize the service of the petitioner by the Annexure 11. Yes, 39.
11. They have regulation. Now, what is your complaint now?
With effect from 2/9/23.
So it should be antedated.
They are saying it is
antedated and to grant pension.
Because you have killed the time of the city. You should have yet an
Let me file the response, Madam. Let me file the response.
issue emergent notice. Monty accepts notice for official respondents. First off, this being third round of litigation. Call this matter week after next. Finally. Yes.
Item 19.
May I please?
Yes.
The petitioner is a PET teacher. His candidature for regularization by the impugnator has been rejected after 11 years of continuous service on the ground that he has lack of qualification as per that advertisement at the time of
Do you have the qualification?
I have the qualification, but from a different university.
From different university?
University. Only
one second. After making one statement, you have to have pause because I have to process it. Whether qualification said it should be from particular university?
No.
No.
Not from particular university. So, impugnator, 36. 36. Second paragraph, that is the criteria. In case of a PET, a candidate should have minimum +2 with CPED qualification. 36
of your petition.
My lord.
That is, it is mentioning about the director of that. The government have not having required qualification as prescribed in the advertisement.
Yes, madam.
But you have that qualification.
I have the qualification.
Take me to your through your advertisement.
Advertisement, it is mentioned, my lord, that is of the 2013, and that is mentioned in page 36 upper second para. Second para. Page 36.
In case of PET.
In case of PET, I am a PET candidate. Should have minimum +2 with CPED qualification. CPED is the certificate in physical education. That was from the Board of Secondary Education, Odisha.
Degree and PG
also, that is a separate thing. I have
consideration. The short point is issue emergent notice. Mr. Mohanty is requested to learn DG. Mr. Mohanty is requested to accept notice for respondents.
For the respondents.
First off, since a very short point relating to requisite qualification of the petitioner for the purpose of regularization is involved in terms of the advertisement. Come on, call this matter after 2 weeks, 3 weeks.
3 weeks. My lord, I am seeking interim order. Pursuant to this order, rejection order, they have issued so called by annexure 10 to disengagement from the service.
Till next date of hearing, no adverse action shall be taken against the petitioner in terms of notice dated.
In terms of 28/6/25, right? Annexure 10. Okay.
Item 20.
Petitioner before your lordship is a private hospital. As per the scheme of the government, that is called Gopabandhu Janna Arogya Yojana, they are giving the benefit to all the hospitals so that they can treat the patients without taking any charge. And the government will reimburse those charges.
In a similar matters, any decision is there of any of our brother judges?
No, decision I have annexed.
You annexed?
But yes, my lord.
Which is that?
That is at page 87.
87?
My lord.
Where is your representation?
My lord, here is the case. Because of non-renewal of the fire safety certificate.
Yes?
Fire safety certificate.
Safety certificate.
Yeah.
Okay.
They cannot, my lord, give that
reason.
Now, the government of Orissa have come up with an amendment relaxing some of the conditions.
Whether this condition is included?
No, to get, no, fire safety certificate is mandatory. To obtain fire safety certificate, the government of Orissa have issued a notification where some things have been my lord, that the house, the approval of the CDA.
I do not know your Oriya language. Unfortunately, learn that.
Relax some of the conditions.
Relax some of the
conditions. They are that has not been renewed on the ground that approval of the development authority was not been obtained.
Who should have obtained that?
Hospital.
You did not obtain.
No, that has been relaxed. That is not necessary.
Requirement is not
necessary. Okay. My lord. In similar matters, my lord, your lordship can see notice was issued.
We will issue that. We will believe you. Why to show? We fully believe. There is no reason to doubt you. Yes. Issue emergent notice. Learned AG, Mr. Monty, requested for sub notice for the all official respondents.
No, my lord. They will take notice for opposite party.
Notice for whom?
1, 2, and 3.
1, 2, and 3, and 5.
Is it true?
1, 2, 3, and 5.
5. Issue emergent notice to the remainder.
And notice by speed post to opposite partner 4 and 6.
By speed post, whatever.
7 also.
4 and 5. You said 5 also, Mr.
No. Government 1, 2, 3, and 5. Opposite partner 4, 6, and 7. I will take notice. First.
Independent organ local body.
Post.
Registered post.
Returnable within 3 weeks. Yes. First. If it is to be furnished in 3 days.
Okay. Well, there is an
call this matter along with which is that?
That is WPC number 18559 of 25.
You are like PT Usha. You run very fast. Brother also along. Yes. You call this matter along with WP number.
And there is an interim appellant, no coercive action shall be taken.
In that matter, they have issued.
Yes.
Next paragraph. Learned counsel for the petitioner on being asked to specifically assert that in the cognate matter, interim relief has been granted and therefore her client should not be discriminated. Rule of parity being the rule of administration of justice. First, I agree. Next, in view of the above, interim order as is made in WP number so and so till next date of hearing. Call this matter along with that WP number so and so. I will copy to them. Copy of the order. Yes. Then I will not say next.
Here, petitioner is a retired government employee.
Retired employee?
My lord. Retired since 31st May 2024.
Retired in 24, last year.
My lord. Initially, he was appointed in a aided school, that means unaided high schools, which has been taken over by the government since 7th April 1994. Thereafter, he's...
what do you want?
My lord, he's not getting his RACP benefit. RACP
means?
My lord, that is
revised assured career progression. SCP and MSCP.
That way.
That
said about this.
Similar and similar matters. Also, Mahapatra case is there. Let me check and verify this and make copy this separate. By that, it will be easier to take care of it.
Sir, 6 by the page note 25, my lord. Available in the
25.
Along with the order of the Honorable Apex Court, my lord.
25. 27,
my lord, order of the Apex Court. And
there are two numbers.
Doubling number was there. In fact, before that also, that Honorable Apex Court. But the original order, it was not given. That will check and verify. That is the Ashok Mahapatra case.
Item 22, the similar matter. And you'll also really see the orders. Order with me. Number of cases, different honorable judges pass the similar order directly into consider. You'll also see different judges. And Delhi, around 10 matters in Delhi.
Daily basis. Regular basis.
100 matters you're also disposing of. So, I see the various benches of the orders. In that light, you're also disposing of matters.
But should he not look into the papers? But should he not look into the paper?
No, you are saying, I cannot say should not look into the papers, but that is a covered matter of losses for convenience.
To say it is covered or not.
Yes, it is fully covered.
You are saying that. He may not agree.
He agree.
At the threshold I have submitted. So let me serve the copy, then it can be decided.
Because
at the threshold I have submitted fairly.
Mr. Mohanty is a very strong government advocate. Before us, he has taken in writ appeal. He said, we have not been given opportunity by the learned single judge. So I have to be careful now, being a single judge. Mr. Mohanty, you accept notice and I'll call this matter tomorrow.
No, my lord. It will be Monday, my lord, next week. It will be easier for me to take the instruction.
Share these copies with your friend also. Issue emergent notice. Mr. Mohanty, on my request, accepts notice. On the request of the court, accepts notice for the respondents. First, learned counsel for the petitioner submits that the subject matter is covered by a curtain of decisions of coordinate benches. No, here many judgments he has got.
No, them same. These are all some.
He waves a dozen judgments to the court across the bar. First stop. Next paragraph. Mr. Mohanty wants a short accommodation to verify and come back with the instruction of his client. First, call next week.
But I am serving a copy, not just.
Share copy also.
Which is serial number? My number is 22. 26. Sorry, 26.
26. But this matter at 26 called us along with this each other. That is, we can make a lot.
अरे अर्धेन्दु का देइछ पवित्र का देइछ गोटे तो असुविधा का दे दूं
Mr. Mohanty, if matter is covered, we can make the same order. Mr. Mohanty, if matter is covered, we can make the same order. Or we want to look into and come back.
Or tomorrow or day after tomorrow, that it will be more easier.
Next week, no problem. Within 1 week, heavens will not fall down. Yes.
Let them serve a copy.
Yes. Thank God.
Item 22. My lord, in this case, the petitioner prayed to release the salary as well as pensionary benefit of our deceased father, of their deceased father, my lord. My lord, in this case, during service,
when he died?
Died 2015, my lord. 15/7/2015. Annex 5, death certificate I have annexed.
1 second. Why 10 years you were sleeping?
Because of official communication, I have annexed all the communication between the parties. My lord, in this case, my lord, during the service period, the father of the petitioner was suspended as because he was in custody for 48 hours in a village dispute regarding election cases.
Automatic suspension.
So automatic suspension.
That is 12(2) of the OCCC rules, my lord. If at all a person will detain more than
that other day, I remember that.
During suspension period,
after what happened?
My lord, no disciplinary procedure. Subsequently, the father of the petitioner, after death of the father of the petitioner, the case was abated, my lord. Criminal case abated, my lord. After death of the father.
Suspension comes to an end on the death of
96. In this case, though the father of the petitioner was suspended in 1996 and died 2015, no disciplinary proceeding was initiated against the father of the petitioner.
For 10 years, no action?
No action.
Mr. Mohanty, just accept notice and come back with your objections. Issue emergent notice. Mr. Mohanty, on our request, on request, accepts notice for the respondents. First, since the matter pertains to the terminal benefits of a deceased employee who was under suspension, call this matter after 3 weeks.
I am for 1 to 3.
1 to 3.
Your notice needs to be also.
In respect of 4, no notice is need to go because
I am made him a party.
Well,
you want to have an order without notice?
Because he has because opposite party number 4 communicated all the areas.
Anyway, you have made him party. Every party has to be notified unless you want to delete. Or you want to delete?
No, I'll send notice.
Issue emergent notice to other respondent. No problem.
Item 23.
My lord, covered by Hemant Kumar Chotter.
Yes, doctor. What is your matter? I am calling you as a doctor.
Yes,
Yeah,
ma'am.
you need not see that side. Who is matter? You are also my daughter. What is the matter?
What is the matter?
What is this?
Pension.
Huh?
Pension.
Pension?
Yes.
Pension not given to your client.
That is covered matter.
Covered matter.
Yes.
Why pension is not given? You don't know?
No.
Then will you tell the same answer to your client also?
It is covered matter by the
Your my lord,
decision.
may I help? This is in grant of retirement benefit because they coming under the fold of that block grant, my lord.
Yes.
Similar matters.
Similar matter that Sarat Parida.
True. Emergent notice. Heard. One sentence. Heard. What's your name?
Vijayalakshmi, sir.
Heard. Love letter advocate. Srimati or Miss?
No, Miss.
Miss so who argued very well. First time. Issue emergent notice. First time. Mr. Mohanty Learned DGA is on request accepts notice for the respondents. All respondents.
My lord, except 4.
Issue emergent notice to respond number 4. Call this matter by speed post. Requisites within 3 days. Call this matter along with serial number. Which serial number?
Possibly, my friend is saying that this is already covered by a pronouncement of reasonable
but he
court.
should know.
Yes.
Every time in the appeal, they were saying,
Yes.
we have not been heard.
Yes. Yes.
Learned judge hastily granted order.
Yes.
While he may be right also.
Yes, my
So
friend
he
also
has to
knows
look
it. Your lordship can fix a short date. My friend also knows it. He was pointing out the addition. The addition reference.
Call this matter after 3 days.
Item 24.
Yes.
Item 24 kindly pass over.
Pass over.
Yes.
Do you have any objection for issuing notice?
No, ma'am.
Issue. Mr. Monti, this requires consideration.
In fact, highly, other parties are there. The state that let notice go to 1 to 5.
1 to 5.
6 is a private party. It should be on rest.
Emergent notice to all parties. Except for whom?
1 to 4, except 5.
1 to 4.
1 to 4.
2 and 4.
No, my lord. 1, 2, 3, and 4.
1, 2, 3, 2. 1 to 4. First issue emergent notice to respond number 5.
Yes, ma'am.
5 and 6.
By 6 post. Other response.
6 also.
5 and 6.
Yes, ma'am.
5 and 6. After 4. Yes.
Item 25.
25. This is also equal to 23.
23.
Yes. That Sarat Parida judgment where I have made a mention. Same on the chapter. That's it. Well, I'll go through.
So you'll accept notice?
Yes. Verify. Kindly verify.
Next week we can call on which date we have posted that matter? Next week only?
That is 2 weeks after.
2 weeks after. We'll call this matter along with WP number. Give the serial number.
Serial number is 23 Miller. 19976.
23. Along with serial number 23. Yes.
Item 27.
May I picture?
Yes, sir.
This is a matter relating to transfer, your lordship. But he is working as an assistant teacher.
Assistant teacher? In which school?
That is in PUPS S. Raghunathpur School.
Is it an aided institution? Government institution?
It's a government institution.
Government school.
Now, my lord, what has happened?
1 second. Since how long this is he or she? He. But you should learn to write Mr., Mrs., etc. Yes.
But in fact, no, usually their transfer takes place only when there is a contingency. Here, your lordship will see the petitioner is having disability of 50%. I am conscious that and the government of India has a notification where persons having disability, normally they should not be disturbed. Whereas the state government is concerned,
where is that?
That I have annexed at page annexure 2.
Go to annexure 2.
My lord, page 10, last clause your lordship will see. But I'll be failing in my duty that the government has also a notification, state government has also a notification in place where they say it's 80% disability. Whereas I am having a 50% disability. I am not disputing that. With your lordship's kind permission, I am producing the notification also. There are other issues like minor children having disability and other things. I have a kid of only 4 months. That is true. I have made a representation to the DO who, my lord, in fact, issued the order of transfer. And your lordship will find, though, my lord, they may not indicate, but the order of transfer also doesn't indicate any administrative exigency. The place where I am working is not surplus. I am within the zone. Teacher and student ratio, I am within the zone I have stated in my petition.
But transfer is the prerogative.
I am not disputing that.
Yes.
Man, there is in the notification, there is a provision for appeal. In fact, instead of an appeal to the director, I have made a representation to the DO itself through mail. That has not been responded to.
No, but the appellate authority who?
Director.
Then I should have sent that to the...
That has not been done. I must concede, madam, that has not been done. If your lordship pleases to decide my fate here, that is one part. If your lordship pleases to...
appeal is there because why appeal there?
I'll go to the director.
Why appeal? Appeal because they will be knowing which school, how many, what is the staff strength.
Not obliged, man. Not
I
obliged.
cannot say. There will be not anything about your school.
Fact finding inquiry, which possibly your lordship may not like to do because it's not be done in a read jurisdiction. I'm conscious of that. So therefore, what I will humbly pray, your lordship may...
What I suggest to you is, in the light of Varadha Rao, you make a representation appeal to the director. That appeal will be decided within a period of 3 weeks.
I will only humbly pray. Till then, your lordship may keep it in abeyance. That much I will humbly pray.
Why you are a lactating mother?
No, I'm not mother. I have a kid of 4 months. Mother will look after. Mother will look after. But your lordship knows here, they are not that forward to take care of it.
No.
Only your lordship.
That's what is that.
No coercive action.
That's your version. Give us some evidentiary material in support of your version. That mothers are not looking after the...
Mothers are not looking after.
Cannot be everywhere, therefore...
In my duty, if I say that mothers are not looking after, I said that most of the mothers are not that forward to take care of themselves and the kid independently.
Do they need any education? They don't need anything. It's biological instinct to the progeny.
My sincere lordship has been pleased to say that I will go to the appellate forum. I am only praying till I move the appellate forum, I may be protected.
There only.
Only no coercive action.
No.
Otherwise, what will happen? They will initiate a proceeding against me.
Petitioner, teacher is grieving against his transfer to another place. First, learned senior advocate appearing for the counsel on record for the petitioner submits that he has a baby from the wife, and wife will not be in a position to look after the baby in his absence. He has already made an appeal to the DO. Not DO.
In fact, it is a DO, they have done it, but it should be to the... Whereas it should be to the director.
To the DO. And the same is not yet considered. And therefore, a direction being issued to consider the same. And that till consideration happens, the impugned order should be kept in abeyance. First one. Next one. Learned AGA appearing for the official respondents, Mr. Mohanty, in his usual style submits that transfer is a matter relating to prerogative of the employer. Wide Varadha Rao versus State of Karnataka, which is that judgment. Researcher.
Varadha versus State of Karnataka.
Varadha Rao versus State of Karnataka. You are not, sorry. We don't have a researcher set up in that board. Okay. Which AR 19?
Back to
86 Supreme Court?
1955.
Very good. What's your name?
Sachiranjan Mehra.
In fact, he is also my associate.
Wonderful, wonderful. But you do not know.
It is not that way, my lord. The reference.
These are day-to-day run-of-the-mill cases.
No, my lord, that I know. The decision I know.
Anyway,
but the reference your lordship is saying, it is not possible to remember like your lordship.
No,
that
I
much.
also do not remember. Therefore, I was.
We have always said that.
In fact, in the Bhagavad Gita, there is a shloka which says, Smriti Bhramshat Buddhinasho Buddhinashat Pranashyati. If you lose your memory power, your downfall begins. This is what Bhagavanta says. Anyway.
Only we are not able to do that. But it's not that I do not know the decision.
Yeah. Prerogative of the employer, Wide Varadhara versus State of Karnataka, year 1986 Supreme Court. So, first semicolon. Secondly, the grievance can be worked out in an appropriate appeal if filed before the
director.
No. Another, you said, Ponti said another.
DU.
DU. Director of?
No, Director Elementary Education Orissa. District, not District Education Officer. Plus 5 ता देखो किंतु से पक्ष ही ना है ही ना तो स्टेट का पक्ष ही क्या होगा.
However, Mr. Mishra, you have filed appeal before whom?
No, I have made it to the DEO, District Education Officer.
However, appeal is made to the incompetent authority, that is the District Education Officer. So, therefore, no relief can be granted to the petitioner. Next paragraph. Having heard the learned counsel for the party and having perused the petition papers, this court is of the considered opinion that the subject appeal ought to have been referred by the district education officer to the jurisdictional appellate authority on his own when he did not have the competence, or at least he should have pointed out to the petitioner the true position as to right of appeal, and rightly contended by Mr. Senior Advocate Mishra, appealing for the petitioner. First of all. Anyway, we shall not stand on the formality, and suffice it to say that petitioner should be permitted to file appeal before the director of elementary education. So within a period of petitioner should be permitted to file appeal within a period of 2 weeks, and till then you should not disturb him. It will be meaningless.
1 minute.
You will file it within 1 week, within 2 days.
AM7 2025. In the meantime, if at all it has been carried out, then if at all,
I will make it clear.
If at all not really,
if it has not been carried out,
if it has not been carried out, then it should not be carried out.
See, he should feel justice is done to him. Nobody comes.
Man, I am conscious and I am standing on the way.
I understand.
But my predicament is that man, they have made a notification now giving power to the MLA to suggest for transfer, which should not be. They have given an amendment.
MLAs are transferred.
Yes, let's see.
Anyway, you have not gone to any MLA, rightly. Within a period of 3 days, you find that.
3 days.
3 days, appeal. Within a period of 3 days. And should the one be filed accordingly, the same should be heard and decided within 2 weeks, within the outer limit of 2 weeks. First, all contention to be kept open. First, to facilitate due consideration of the appeal, the respondent authorities are requested not to displace the petitioner, if already not displaced.
Yes.
Okay.
So grateful, man.
Of course.
Now, may I pray for urgent copy course of the day because I have to file it within 3 days.
You file it. Why do you want copy? We'll give you. I will sign the copies.
It would not say anything. We get a copy, but we normally pray for urgent copy because urgent copy, if your lordship it is mentioned, we get a copy immediately.
Copy to be acted upon by all consent.
So grateful.
Item 30.
At 28.
Agenda.
And in this case, Miller, the present petitioner is continuing as a Hindi teacher, Miller.
even though he has completed 48 years, my lord, but the authorities are not giving trend scale of fee, my lord.
Scale is not given.
Trend scale, my lord. On trend scale, the petitioner is getting on trend scale of fee. Even though he has completed 48 year age, attains the 48 year age, has not given the trend scale, my lord. As per
which scale?
Trend graduate scale of fee.
Graduate scale of fee. To others they have given.
Yes, my lord. In the meantime, my lord, the similar issue already been decided in the case of Radharani Samal versus State of Odisha and others, reported in 2017-1.
Where is your representation?
My lord, my representation under Annexure 4, page 21.
What one example?
Page 21. Ma'am.
That is Radharani Samal versus State of Orissa.
My lord, my lord.
Brother, consider that representation in the light of that decision. Will it be all right?
My lord.
The short grievance of the petitioner is as to non-extension of a particular pay scale, despite making a representation dated 4/2/2025, a copy whereof awaits at the Annexure A4.
Annexure 4. Annexure 4.
Annexure 4. Annexure 4. Learned counsel for the petitioner submits that Article 350 of the Constitution casts an obligation on the authorities to consider all representations of the citizens and the grant grievance, redressal to the grievance aired therein. And this having not been done, the petitioner is knocking at the doors of this court. First, next paragraph. Learned standing counsel, Mr. Mohammed.
Yes,
So, on request of hearing for the official respondent, opposes the petition, contending that no right accrues in favor of the petitioner, and therefore, in the absence of such a right, writ petition is not maintainable. First, having so stated, now he, in all fairness, submits that he would instruct his clients to consider the subject representation within a period of 6 weeks and in accordance with law. First off, this is appreciable. First, next part, in the above circumstances, petition is disposed of with the suggestion that the consideration of the subject representation should happen in the light of Radharani Samal versus State of Orissa 2017 1 ILR CLT 546 and the extant rules, if any. All contentions of the parties are kept out. Because the result of consideration should be made known to the petitioner within 4 weeks. 4 weeks. Failing which, in the next level of legal battle, heavy costs may be ordered.
In case of 4 weeks, I believe 8 weeks.
8 weeks.
2 months.
8 weeks. 8 weeks. Now that includes reporting that also. Okay.
Item 31.
Within 8 weeks, you have to inform him.
My lord.
We have considered, allowed, rejected, whatever. You should inform him.
Yes, my lord.
Again, he should not be made to come to your office. Yes.
May I please, Your Lordship?
Yes.
May I please? In this person, my lord, this is the second round, my lord, litigation, my lord. Earlier, I was approached before Your Lordship, my lord.
Item 31.
31. 30 is over, no?
Yes, one, my lord. May I please, Your Lordship? In this person, my lord, I am challenging the order dated 28/7/2024, my lord, passed by the collector, opposite pen number 2, my lords. Earlier, my lord.
Disengaging the petitioner.
My lord.
Disengaging the petitioner.
My lord. Earlier,
how many years you have put in service?
My lord, earlier I was approached before Your Lordship, my lord. Your Lordship directed to opposite party to consider my representation. Thereafter, he rejected this time. Thereafter, I approached before Your Lordship, my lord.
No, how many years you have been in service?
Well, Lady Matron, my lord.
You are not answering the question, brother.
My lord.
How long you have been in service? That's the fundamental question, na? In all matters of regularization. First sentence will be petitioner has been in continuous service
From
for a period of so and so, with effect from so and so.
from date of 2016, my lord.
2016.
My lord.
9 years you have put in.
My lord.
Have they quoted Uma Devi?
No, my lord. This is my lord. Lady matron, my lord. In your hostel, my lord.
Is it a contract?
Contractual
This
basis.
is my lord, in the tribal hostel, my lord. One of the student he has killed, my lord, because of negligence, my lord. But that is
Killed?
yes, my lord.
Murdered?
No, not murder.
Committed
Because
suicide?
of his negligence, he
died.
Lack of, my lord, health facility.
Any action is taken against
Yes, my lord. As per the previous direction of the Hon'Ble Court,
Jerry
the collector has
Is it Srimati, Mr., Mrs. what?
My lord.
If somebody addresses you without any Mr., Mrs., what will you do?
Mrs.
Mrs.
I know.
Well, your registry is not insisting. Apex court said you should mention that. Mr., Mrs., etc. Somebody was killed.
My lord, the because of his negligence, he was absent, and as per my lord's direction, the collector inquired into the matter and suspended the other employees, and he is in continuing temporary status, my lord, for that reason he has been terminated, my lord.
What happened to inquiry?
Inquiry, my lord, annexure 6, my lord, page 30. The collector found that negligence on the part of the present petitioner, my lord.
On her part. Which is that order?
My
My lord, can you see?
524.
Yes, my lord. 18/7/2024, page 30 onwards, my lord.
18/7.
Para 2, my lord, page 31, it reveals from the records file of DWO, District Welfare Officer, that is my lord, Mayurbhanj, that our receipt of the information regarding
The inquiry.
Inquiry, my lord.
To hold her responsible. What is the inquiry?
That I will produce, my lord. For lordship kindly see the order dated, my lord, 20, page 28, my lord. Order dated 23 May 2024. Order passed in double petition number 13484. My lord, 28, page 28 to the petition.
Consider the representative.
My lord.
No, we are asking you. You are kindly do not disturb. You are asking. You are telling that she is responsible for death of a person. Where is the inquiry?
Finding of the collector, my lord.
What finding of collector? Collector is not Brahma. He has to hold inquiry, na? Where is that inquiry?
We will file response, my lord. That's why issue notice will file response.
But why have you this with effect from which date you have disengaged? Last year.
Yes, my lord, last year, 2024.
Whether disengaged since last year, brother?
My lord.
But you have come now.
No, my lord. Earlier I was approached, my lord. Earlier already approached before lordship.
All right, but the consideration was directed, na?
My lord.
By other judge. That itself was last year, more than a year back.
On 21 April 2024, he has been disengaged.
That's what.
Well,
but this is decided in 2024 itself. There are the case for interim order. Issue emergent notice. Submit the standing counsel. Shri so and so accepts notice for the official respondent. First, all after 4 weeks.
My lord, interim application is there, my lord.
The application is there, but since more than a year, you are outside the service. That's the reason. Otherwise, I would have granted.
Short prayer, my lord.
Let us see.
Not fill up the matter.
No, 1 year is over.
My lord.
1 year. We will solve this matter immediately. You file objections within 3 years, 3 weeks. All right.
Yes, madam.
All after 3 weeks.
Item 32.
In this case, the petitioner prays for a direction to the opposite party to regularize her service from the date of her joining, my lord. Instead of 3/7/2016.
They have regularized now.
My lord.
Have they regularized the service?
My lord.
But you need antedating.
and the government passed a common order on 3/7/2016 under Annexure 3 Miller, page 14.
That is for
3/7/2016, Annexure 3, page 14 Miller.
with effect from
With effect from
3/7/2016.
my lord.
Correct.
That order, many of the junior lecturers, they have a preferred read in this honorable court, and that is already quashed, my lord. Thereafter, the government preferred read appeal, that is dismissed. Then they preferred SLP, that is also dismissed, my lord. Thereafter, the petitioner prays for regularize their service from the date of their joining, my lord.
Their initial appointment itself.
My lord.
What do you say, brother?
32. My lord.
Where is your representation?
My lord, similar order.
Where is your representation? Don't take anything without my permission. They will dump all things here. We are asking you, where is your representation?
Repression not there.
No, they have a, but I have an annexed, not annexed. They have a represented, my lord. I have a
Represented.
My lord.
Do you have copy?
I have only taken abatement.
Where is stated? Ali, you need not produce. Where are you stated in your petition that you have given the representation? Any document without permission of the court, you should not take.
Annexure 9.
Annexure 9.
My lord, page 7.
Go to Annexure 9.
Page 7, Annexure 9. Sorry, page para 9, my lord.
Para 9.
Para 9, page 7.
Issue emergent notice.
But I will file a press.
Let us see what he will say. Learned standing counsel on accepts notice on my request. On this. Call after 4 weeks. The representation should bring the representation the next date along with a memo.
Item 33. My please your lordship.
Yes.
Similar. In this case, my lord, I prayed for adjournment because it crossed up the case.
So it's a request of the counsel appearing for the petition. This next.
Item 34.
May I please, my lord? In this case, my lord, there's a third round of litigation, my lord.
Third round of litigation?
My lord.
Pertaining to what?
My lord,
mandamus is sufficient.
Yes, my lord.
But for punishment, I'm asking a question to you,
yes,
since you are an youngster.
My lord.
For flashing, which is the writ? Which writ? In English law, there were 208 writs, but we do not have so many writs. For flashment, which is the appropriate writ? Writ of certiorari.
Writ of certiorari.
But you have said mandamus.
Any other writ also.
All right. Why are that? It's of certiorari.
My lord.
Or you can say appropriate.
Also, direction is need to be issued, my lord. That is why.
You have sought for direction also.
My lord.
You're right.
Against the order of termination, the petitioners have approached the opposite party number 2, my lord. The appeal was heard and it has been rejected, my lord.
Appeal is rejected now.
My lord, under Annexure 1.
Page number?
Page number 11, my lord. Without affording the opportunity of hearing, my lord.
But it's a very long, lengthy order.
My lord.
You are not heard in the matter.
I have been heard in the appeal, my lord. But my contention has not been taken into consideration.
Which contention has not been taken?
That, my lord, your lordship may kindly see. I was appointed as third peon, my lord. In 16/4/2009.
No, which contention is not considered by the authority?
The time when the order of termination was handed upon to me, no so-called notice has been issued against me, my lord.
Straightway they issued.
Straightway, my lord. There is no communication of the so-called notice to me. Even though so-called notice was issued, that has been reflected in the during the appeal period.
but no communication has been made to me.
Where is your appeal memo? Show that in the appeal you have taken that ground.
Page 24, my lord.
24.
Page 24. This was a representation, my lord.
Where have you stated that no show cause notice was not given to you?
The third paragraph, my lord. While continuing as third peon, this was a 2010 representation, my lord.
No, I'm asking you.
That my lord, that has not been stated here.
Then?
But at the time of hearing of the appeal.
Not for hearing of the appeal. In the appeal memo, you should take up that contention. Whatever contention you have taken up, those contention appellate authority will address. If notice was not issued, that would have been the first ground. No notice is issued to me. Would have been the first ground. Nothing. There is nothing in the matter. They have heard and decided. How can we decide now?
There is a provision in the Education Act, my lord. If the notice has been issued, but no communication has been made to the opposite party.
Where have you stated that?
Lordship, I was for the council at that point of time.
That makes no difference to us.
This person is the third peon, my lord.
That makes no sense, sir. You may be, other advocate may not be as intelligent as you are, but point is, question is not advocate, question is the litigant. Nothing.
The management is the appropriate authority at that point of time, my lord. Without affording him an opportunity of hearing, they dismissed him directly.
You are only.
The Lord may kindly see the termination order.
Termination order, all right.
Termination order that is written in Odia.
Where is that?
Under annexure.
Read that particular sentence. I may understand, I do not know. Read that sentence. Where have you taken up that contention?
That termination order I am reading in Odia, my lord. Annexure 4, page 21, it has been stated. आपनको नोटिस दिगला सत्वे आपण निज कार्य योगदान न देबारु परिचालना कमिटी अधिवेशन नंबर सच एंड सच अनुसार आपनको बहिष्कार आपनको विद्यालय तृतीय पियन पदवी बहिष्कार करागला नथिंग मैन
The committee took that decision, passed the resolution removing you from service.
It is hereby notice that if at all you will not join in service, so management has taken a decision that he will be
relieve you.
No date has been mentioned, madam. Whether I was continuing or not, the particular date, they are saying that notice has been issued, my lord. But no notice was issued.
Where have you stated that?
That I have taken my abatements in the writ petition, my lord.
Writ petition, no. You have to tell that in your appeal itself.
That appeal petition was heard, my lord. Appeal petition was heard in length, my lord.
1 second. Please do not divert the attention of the court. That may not help you. You may lose this case, but you may lose other case also. Therefore, be little honest to the court. Where have you taken up the contention that you were not issued with notice? Notice sent by the management did not reach my hands. Where is that contention? That you said you were not taken. You said the other advocate was arguing, etc.
Lordship may kindly see page 24. That representation, what he has made to the
in that
director.
It is not stated.
Last para, my lord, Lordship kindly
stated.
I have worked in the school from the date of my appointment without any remuneration, awaiting the school to be eligible for receiving block grant. On such illegal termination and behavior of the secretary as well as the headmaster in terminating my service and preventing me physically to discharge my duties, I have been harassed and depressed. Therefore, I request.
My question remains unanswered. What you read is useless to me. I am asking question. Where have you taken up the contention that no notice was served on me?
Then I will take instruction about that, my lord.
Where is the question of? Can you improve this forward? How can you improve by argument if you have not taken up that contention at all? Take chance before some other judge. I don't want to damage the first day itself. Call after 4 weeks at the request of the counsel appearing for the petitioner. Yes.
Item 34,
35.
35.
35.
35 matter. This is the second round matter. Rejecting the claim of the petitioner for grant of a headmaster scale of pay matter.
Scale of pay is not given to you.
No matter.
To others they have given.
Others, my lord, this issue has already been decided in the case of Purnachandra Chand versus State of Odisha, my lord.
Where is your representative?
My lord, representation has been rejected, my lord.
Rejected.
Earlier, the petitioner approached this honorable court. This honorable court directed to consider the case of the petitioner by taking into consideration the judgment rendered in the case of Purnachandra Chand versus State of Odisha, which was also confirmed by the honorable Apex Court.
Issue emergent notice, standing counsel accepts notice on request. Call up to 3 weeks.
Item 36.
May I please, Your Lordship?
Yes, sir.
Madam, the present petitioner claims parity with the similarly placed teachers, those who have been appointed pursuant to one resolution, my lord. My lord, the present petitioner was initially appointed as
Same resolution.
same resolution. Your Lordship,
Parity in respect of what?
my lord, the present petitioner was initially appointed on contractual basis as a trained metric teacher, and pursuant to the very same resolution, some teachers were appointed on contractual basis as trained graduate teachers. Both category of teachers were regularized after completion of 6 years. My lord, in the year 2023, Government in School and Nursing Department brought out a resolution, which may kindly come to.
Which is the decision Apex Court said where you cannot discriminate when people are appointed. Similar point of people are regularized in service. You cannot, which is that judge?
My lord, instantly ignore.
Issue emergent notice. Summons for 2024. 2024
judgment, my lord.
Just look into.
My lord.
Issue emergent notice. Learned standing counsel accepts on request accepts notice for
all the opposite parties, my lord.
Of all the respondents. Give copy.
My lord.
Yes. Call out 4 weeks.
Item 37.
Lordship, item 37 may pray for Passover.
Passover. Take this.
Item 38.
Yes, sir.
Lordship, the opposite party number 3, sub-collector is not allowed to the respondent to file the reply of the appeal, Your Lordship. So, Your Lordship, the sub-collector
to adoption.
Adoption, Your Lordship.
What is that matter?
The matter is, Your Lordship, the legal appeal, the legal appeal is pending. During the pending of the appeal, in the meantime, respondent died, Your Lordship.
During the pendency of the appeal, respondent died.
So they have not allowed to substitute the legal heirs, Your Lordship, of the respondent. Yes. So thereafter, the sub-collector has passed the order, Your Lordship, in favor of the appellant, Your Lordship.
Appellant?
Yes, Your Lordship.
And you were the respondent?
Yes, Your Lordship. So now
you have not made a party?
No, Your Lordship.
You are adopting child?
No, I am the respondent in the appeal, Your Lordship. The present petitioners are the legal heir of the deceased. Yes.
Who are the deceased respondent?
Your Lordship,
in the appeal?
Your Lordship, for a moment, kindly turn to page 83 under Annexure 11, Your Lordship. Mahalakshmi Samal.
She was a
yes, Your Lordship. Your Lordship, the opposite party number 3, sub-collector, has passed the order dated 11/3/2025. And for a moment, Your Lordship, kindly come to page 82 under Annexure 10, Your Lordship. The respondent died on 9/11/2024.
So the
1124.
yes, your lordship.
That Mahalakshmi.
Yes, your lordship.
Then
Your lordship, the counsel of the respondent has prepared the draft counter reply, your lordship, but they have not allowed and they have passed the order, your lordship.
without bringing a lot of.
Yes, your lordship. So as per the section 11.
How can you pass order against the deceased person? Appeal can abate if the LRs are not brought on record. This is what Apex Court said. How can you pass an order against a dead man, dead person, lady? Mahalakshmi died.
Yes.
Their death certificate is produced.
Yes.
And which says specific all particulars.
Valid. I'll take instruction.
Yes. Issue emergent notice. Which date they did it, brother?
Your lordship, that is order first 11/3/2025 at page, your lordship, 83 under annex 11, your lordship.
Okay. Issue emergent notice. Learned Standing Council accepts notice for official respondent. Who? Official respondent.
Your lordship, that is sub-collector opposite party number 3 and Tahsildar
opposite party number
1 to 4. 1 to 4.
1 to 4.
Yes.
Issue emergent notice to private respondent.
Yes.
You are sought for interim order.
Yes.
Where is it?
Your lordship,
application is filed.
Filed.
Next paragraph. Issue interim order of stay. Stay in the operation of impugned order. First, this interim relief has been granted on the prima facie satisfaction of truthfulness of the assertion of counsel for the petitioner that the impugned order is passed against the dead person, namely Srimati Mahalakshmi
Samal.
On 9/11,
that is 2024, your lordship.
9/11/2024.
Grateful, your lordship.
Yes.
May I please, lordship?
Item 39.
39.
There is the petitioner is a challenged under annexure 2, my lord. Annexure 3. Annexure 3.
What is that?
That is the appointment of a new distributor.
Appointment of new distributor.
Under opposite party number 1.
For distributing what?
For a sale of a milk product.
Milk products and ice cream.
My lord. In this regard, similar other identical case is filed and that is urgent to.
No notice is issued.
And that is posted for final hearing.
Final hearing.
My lord. My lord, may I take this case to.
That also we follow the same this month. That's just one thing.
Federation is the concerned opposite party, and for federation, I have entered appearance and filed counter in number of cases, 10 to 12 cases.
Give the list. Do you have a list of the cases?
He should be having.
So that we can post bunch all those matters and pass common order.
Can conveniently share it, my lord, in course of the day.
No. A learned counsel for the petitioner submits that identical matters, coordinate benches of this court have already issued notice, and those matters are posted for final hearing. First up, learned panel counsel appearing for the
Federation,
respondent federation of contractors. Federation of what?
This milk federation, state level Apex
federation.
Cooperative milk federation.
Which respondent?
Copy number 1. He has not given the copy, my lord.
You copy proof.
I think all the opposite parties, 1, 2, 3.
You appeared for all this one? The counsel appearing for the
same here, my lord.
Submits that. Several such matters have been pending with various benches of this court, and all they can be bunched together along with this and be heard and decided. First off, the learned counsel is a counsel for the petitioner agrees with the proposal rightly. First off, next paragraph. In view of that, issue notice to the respondents, semicolon, learned panel counsel Shri accepts notice for all the respondents. First off, petitioner has served a copy of the petition along with the documents right in front of the eyes of the court. First off, call this matter along with the other connected matters
6344 of 2025.
WP 6344 of 2024.
25.
PC 25, etc. Other matters are also there. Just give entire list you have given.
Item 3940 and rest of the entire list, my lord, I'll share.
In that only.
My lord, item 40 also same order.
41.
Yeah, 40.
No, 39 and 40. Both are
39 and 40.
My lord.
1 second. This time. Take this. 39 and 40. One common order. 39 and 40. Okay. Yes, brother.
Item 41.
Item 41 is a matter relating to obtaining fire safety certificate.
Fire safety certificate.
Yes, my lord. As similar to item number 20 of today's list, my lord. And I am filing the
that madam had argued.
Yes, my lord.
That nursing home matters.
Issue emergent notice, Mr. Standing Counsel. Standing Counsel on request accepts notice for the all respondents.
Okay. Not all respondents, my lord.
All respondents. Call this matter along with the serial number 20.
20, my lord.
20.
My lord, IA is there, no coercive action.
The interim order, as has been granted in the serial number, that refers to another judgment, na?
Yes, my similar identical matters. All are similar.
Serial number 20.
Except, my lord, opposite party number 4, my lord.
3.
Except opposite party number 4.
4. Issue emergent notice to respond number 4. Requisites within 4 days. First one. Interim order shall not be released till requisites are published.
Item 42.
May I please, your lordship?
Yes, sir.
Petitioner is the junior clerk, also retired in the meantime. Junior clerk in the school, high school.
Junior
Clerk,
accountant.
in the Dukura New Government High School in district of Mayurbhanj. It's third RSCP. It is not been sanctioned as per the Orissa revised scale of pay rule.
This is career advancement scheme. Similar to
Ashok Mahapatra.
the serial number what?
This is item 21.
21. Issue notice. Learned
Needs to be Monday.
parent counsel. Learned counsel accepts notice for respondents. First one. Call this matter along with the.
My lord, similarly situated, my colleague is been already order has been passed in another school.
He has to look into. Monday we will call that. In the meanwhile, he will assert. Call along with the serial number 21 along with serial number 21.
Item 43.
Yes.
Here the petitioner is the governing body of a private unaided recognized institution, degree college, challenge the order of the passed by the Director of Higher Education, wherein the Director of Higher Education, while discharging the duty of appellate authority, allowed the appeal preferred by the opposite party number 4 only on the ground, Annexure 5, that there is no valid governing body in the college, therefore the termination is bad in law, and directed to reinstatement of the number 4 along with all benefits.
Who can terminate?
Governing body.
But there was no governing body.
There is governing body. That is
the correct order.
Yes. Kindly see, my lords. The director passed the order basing on the fact that governing body which was constituted by the prescribed authority on 5/7/2021 for a period of 3 years.
Governing body was constituted.
My lord. Annexure 5, page 32.
Constituted on which date?
5/7/2021.
5/7/2021.
For a period of 3 years.
The duration of this
3 years.
3 years.
3 years. As per the 91 rules. And that governing body, by the Annexure page 34 on 25/1/2022, before expiry of the term, was cancelled.
Within the 3 years.
Within 3 years, after 1 year, the governing body was cancelled on 25/1/2022. On the very that very order.
Slowly, one sentence. You have to pause. date on which date dissolved?
Yes, on 25/1/2022. But in that very letter, cancellation letter, the prescribed authority also directed that the college authority to constitute the governing body as per the proposal submitted earlier, that is on 9/6/21, and to intimate the undersigned. Accordingly, in view of that 25/1/2020 letter, the governing body was constituted, and that on my lord 18/10/2022. That is at page 38, and also communicated to the all authority. That part has not been taken into consideration by the opinion number 2 while that.
So your contention is as on the date there was a governing body.
Yes.
Where how that is treated, that contention is treated by the concerned authority in deciding the appeal against you.
That you also kindly see the impugning order.
Which page treats this contention?
Page 31.
31.
Page 31. Only one paragraph. Top. On perusal of records submitted by the principal of the college, it reveals that the governing body of the college was constituted by RD letter number so-and-so dated 5/7/21 and has been dissolved by office order dated 25/1/2022. The college authority did not submit any document regarding reconstitution of the valid governing body. So after dissolution of the governing body of the college, the decision made by dissolution number 42 by the GB.
You did not bring to the notice of the authority that 18/10/2022.
Yes.
Where is that contention?
Content I have specifically stated in the present petition.
No. In your objection.
Objection I have not filed. The very day appearance, the director passed the order. That is also my case. On the very first day of appearance, principals appeared and submitted certain documents and sought for time to file counter, but the director closed the hearing. In fact, director is not hearing, heard the matter. The assistant director had the matter and the director passed the order. That is a specific case, in the present case.
He has not heard of the matter at all?
No matter. And not filed counter also. On the very first day, that was heard and disposed of. I was only served with the appeal memo without annexure. Only appeal memo I was served on that day, and that on the very day the matter was disposed of. And that is admitted document, page annexure page 38, the governing body has been constituted.
Sir, you appear for respondent.
Yes, sir.
He says governing body was there.
No, the order is very clear.
What is clear? Should he not be given reasonable time to file the documents?
Well, I'll take instruction.
Sure. Emergent notice. Learned standing counsel on request accepts notice for the official respondents. First of Shri
P.K.
Monti appears for, learned counsel appears for
1 to 3.
1 to 3. Full stop.
4-5 notice to.
Issue emergent notice to 4 and 5.
4 and 5.
Full stop. Stay of impugned order till next date of hearing.
Annexure, my lord, what is? Annexure 4.
Annexure 4.
2/7/2025.
Sorry, so we can just make this.
Obliged.
Till next date of hearing. First stop. This reprieve has been granted on the assertion of learned counsel appearing for the petitioner that the new governing body was constituted with effect from 18/10/2022 and that even to place this evidentiary material, no opportunity was given by the answering official respondent. And that for that, absolutely there is no justification.
Item 44.
You answered very well. And one thing, best books on art of argument, like Gerald, etc., they say, when you make a statement in the court, you have to wait.
Yes.
See how judge is responding to that, how he is processing it. Then make next sentence. He says that. They read that book. That's a good book. Art of Argument by Gerald, the Mufazil lawyer in America. One of the best books I have ever seen. Art of Communication and Connection also. Yes.
Item 44.
And these minutes. Yes. Here is the case, my lord. The husband of the petitioner, while conducting a lecture in Odia, he expired. The petitioner earlier approached after Disciplinary Court in 1997 for grant of family pension. My lord, this one directed the opinion number 2 to take a decision on the representation petitioner.
According, no action taken, again I approach in 2099, my lord. Ultimately, this one directed, he examined the matter, he found eligible, grant pension.
Then direction.
Yes. Thereafter, unnecessary loan is issued by the director.
Saying that you are not eligible.
Eligible. Eligible. Eligible and some payment is also released. But thereafter again they have connected 3, the control accounts stopped the pension. I approach my lord. My lord, during pendency of the case, they released my family pension. Unnecessary 5, but unnecessary 5 they have released. But kindly see my lord, in pre-revise of 1988, thereafter my pension not revived until that. Refixation 91, 98, 2008, not revived till that, my lord.
Why this lady is being
lady?
There is a pension payment order also.
Yes, unnecessary 5.
Issue emergent notice. Who appears for the respondent? See, registry, tell our registry to put a flag to the cost title. I cannot spend time in turning the pages like this.
1 to 4 comment, my lord.
1 to 4.
Comment.
Mr. Monty, you accept notice for 1 to 4?
Yes.
Standing counsel accepts.
Yes. Additional standing counsel.
Additional standing counsel accepts notice for respondents 1 to 4. All respondents.
Yes.
All respondents. First of all, this matter immediately after 2 weeks, since it involves withholding of pension payable to the petitioner.
Item 45.
Petition is retired lecturer in fully aided college, my lord, and he has placed group A scale, my lord, in the year 2007 and senior scale 2017 as answer 4 page 39, my lord. As per the rules, my lord, he is to group A after 8 years of full aided, 8 years and 18 years to become the senior scale, my lord. Similar matter they have raised before one Chitranjan Das, my lord, by answer 5, the render a judgment with this honorable court.
You have given the representation.
I have given the representation, that is annexed 8.
Pending matter.
Annexed 8.
Pending matter.
It is pending.
Yes.
To consider that representation, take a call on that representation.
Yes.
The short grievance of the petitioner is as to non-extension of a particular pay scale on the happening of on the completion of the block period of service, in terms of extant rules governing the issue. First, learned counsel for the petitioner, invoking Article 350 of the Constitution of India, submits that when a representation is given by a citizen airing the grievance, it is the bounden duty of the authorities to grant redressal within a reasonable time. First of all, this having not happened, he submits, the client is before this court. Next one. Learned standing counsel appearing for the official respondents, having resisted the petition for some time, now agrees with the suggestion of this court that the answering respondent has to take a call on the subject representation, a copy whereof awails at Annex 8. Correct?
Annex 8, my lord.
Is it right?
Yes.
Dated
Page 80.
6/1/2025. If all contentions are accepted and a reasonable period is granted. First of all, this is fair enough. Next paragraph. In the above circumstances, this petition is disposed of, prescribing a period of 6 weeks for consideration of the subject representation and reporting the result of such consideration to the petitioner as well. First of all, non-compliance would be viewed very seriously, and at the next level of the legal battle, heavy costs may be imposed, personally payable by the answering respondent. Next, all contentions kept open.
Item 46.
Lord, here
Yes, for the
petitioners have made their grievance before the DFO, the Divisional Forest Officer. That is Annex 3, my lord. I'm sorry that it is in Oriya. But they are.
Why should you be sorry? Oriya is the language of the state. I should learn it, actually.
I have not. translated it that is why. My lord, here, my lord, their grievance is that the village protection committee or village submersion committee, which was constituted in the year 2018, that has expired after 3 years. Now the village protection committee is not there to protect the reserve forest. The local forester, along with the previous president of the village committee, they are trying to cut and fell the trees. That the grievance before the DFO, and they have not taken any decision.
Where is that?
That is Annexure 3.
Annexure 3?
Yes, ma'am.
Let them take a call on that.
Yes, ma'am.
Yes.
That
The
is
the petitioner is knocking at the doors of writ court, grieving against non-consideration of their representation dated
6/7/2025.
6/7/2025. A copy whereof avails at Annexure 3. First, then that's under Article 358. Next paragraph. Learned standing counsel appearing for the respondent resists the petition, contending that even the ink on the representation has not dried up, and in the meanwhile the petitioner hurriedly has knocked at the doors of writ court, which is not permissible. First, having so contended, he agrees with the suggestion of this court that he would instruct the answering respondents to take a call on the subject representation in accordance with law and within a reasonable time, should all contentions be kept over. First of all, this being failed, the court agrees with first of all, next paragraph in the above circumstances, petition is disposed of. Time for compliance is 6 weeks. All contentions kept open. Then last line, similar. If no decision is taken, then etc.
Only prayer, my lord. Till then, my lord, the forester at least may not be permitted to cut the trees till a decision is taken, or your lordship may keep it open to raise before the DFO this the question of interpretation.
One sentence should add. Till consideration. Sorry, first of all, it is open to the petitioner to seek interim order at the hands of the DFO to ensure that tree-felling does not happen during the pendency of the subject representation. In that connection, all contentions are kept open.
Item 47.
May I please?
Yes.
Your Lordship.
Yes, sir.
The petitioners are appointed as contractual basis as technical consultant under the School and Mass Education Department since 1998.
1990?
98.
98?
1998.
Yes.
Their services are governed under the Orissa Primary Education Program Authority Service Regulation 1996, that is under Annexures.
These regulations are made under which act?
These regulations are made under the Memorandum of Association of the Orissa Primary Education Program Authority.
Not
that
any
is a
statute.
no, that is not a statute. That this is a aid by central government provides 60% aid and the state government provides 40% aid for the development of primary education in the state. And accordingly, the regulation has been framed, and as per that regulation, we have been appointed. We are continuing since there. Under the regulation, we are continuing under the School and Mass Education Department. That is one of the branches is called OPEPA. Now, under this regulation, there is no scope for deployment of the contractual staff to other department. There is no regulation.
How this question is answered by any of my brother judges, sister judge also?
My lord, previously one technical consultant was transferred from Cuttack to Balangir. Then the transfer order was challenged before this Hon'Ble Court. And this Hon'Ble Court held without any provision in the regulation, you cannot transfer. He is a contractual employee getting a fixed remuneration. You cannot change transfer him.
Judgment.
And your lordship may kindly have a glance to Annexure 2. They are therefore taking view to that.
The two. No,
Annex
copy-
2 at page 61.
No, that I will look into. Do you have copy of the judgment which you mentioned?
Yes, I have.
That appears to be the correct position, actually. No enabling provision in the regulations for transfer. They are all contract employees.
Now the order has been passed for deployment. I am challenging the deployment provision. You can, my lord, I am bringing your lordship to Annex 2 for this reason. Those staff who are previously deployed to PR department, their services has been withdrawn to school and mass education department.
Because of this judgment.
Because of this, there is no reference to this
But
judgment.
appears to be on the basis of.
Yes, in the service of all senior technical consultant and technical consultant working
Please for the respondent. You please.
Let him file a representation before the order.
No,
Representation. Already law is settled by the court, highest court of the state. You can't do that. Why representation? Where have you taken decisions on the representations? Today, 7 representations I have treated. The representations are kept pending in the cold storage. No, you can't do that.
Let him
Issue
apply a copy.
emergent notice. First up, interim order staying the impugned order of deployment of the petitioners. First up, next paragraph. This interim order, this reprieve has been granted in the light of a coordinate bench decision in Surya Narayana Mishra versus State of Odisha. What is the citations?
WPC number
WPC number
12584 of 2019.
Connected with the WPC number 24671 of 2020. Disposed of on which date? All right.
20th of April 2021.
20th April 2021. Generally in court hall, phones are 4 weeks.
Item 41, 48.
Yes, sir.
Petitioner is the assistant teacher challenging the order of transfer.
Transfer order.
Transfer order.
Is he not liable to be transferred?
My lord, first thing is that as per these guidelines, that transfer must be completed by 15th June of 2000. Page.
After that period, nobody can be transferred. Which is that instrument?
Guidelines. Annexure 1, page 19. Joining, issue of transfer orders 5th June and joining of teachers 15th June.
Because it will create other problems.
And subsequently, another thing is that the petitioner is husband, wife,
spousal.
For that reason, there is a decision of that there is a 2 years old daughter, 2 years daughter.
No, daughter, that makes no sense. Everybody will have, in this country, China, everybody will have children. That cannot be a ground for retention. You can carry the child.
And another child is also reading in that school in class 3.
If you have about 10 children, they will have in various standards. What that can be done? No, brother, what is the position?
He is not represented to the director.
They are not given representation.
No.
There is appeal provision to the director.
Yes, there is appeal
we
provision.
treated one matter. You give representation.
Yes, my lord, because they on the same date they are issuing an order of transfer and they are relieving. My lord, in last order, my lord passed order that if it is not relieved, that part.
The appeal was filed there. But you have not filed appeal at all.
Well, then even the same order may passed.
Short grievance of the petitioner, a member of the teaching faculty, is against the transfer. First up. Learned counsel for the petitioner submits that ordinarily, no transfer should be effected after the cutoff date of 15 June 2025. Correct?
Sir.
25. And therefore, impugned order is not sustainable. First, next paragraph. Learned standing counsel appearing for the official respondents on request of the court, opposes the petition contending that transfer is a prerogative of the employer by the Varadhara versus State of Karnataka, AR 1986, Supreme Court, etc. etc. And secondly, the petitioner has got an alternate remedy of appeal to the Director of Education, correct?
Yes.
Director of Education, DEO.
No, it's a Director of Elementary
Elementary Education, Director of Elementary Education. And therefore, he should be relegated to the remedy of appeal. First. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers.
Another point is that Annexure 5, there is a transfer of posting of husband or wife at the same station.
One more point. Learned counsel also presses into service the spousal rule of transfer in support of his contention. First. In the light of transfer, in the light of government OMITs, Office Memorandum number 14151 dated 6/8/1985. First, next paragraph. Having heard the counsel for the parties and having perused the petition papers, I broadly agree with the submission of learned advocate appearing for the learned state counsel appearing for the official respondents. That petitioner should be relegated to remedy of appeal. First, to facilitate filing of the appeal, petitioner is granted a period of 1 week, and till the filing of appeal, the impugned order is kept in suspended animation. First of all grounds are kept open to both the sides. Next, no course. 1 week we have kept under suspension. Within that, you have to file an appeal there, along with the interim prayer.
Item 49.
Yes, sir. The appeal may be disposed of within a
disposed of.
No, that I will file the appeal.
Appeal is filed. Correct. Right. The same shall be heard and decided within an outer limit of 4 weeks.
Till date, till disposal of
the appeal. You don't know if you do not file the appeal tomorrow.
Yes, sir. Till disposal of appeal, it may be considered.
My lord, that's not right. Impugned order. Second paragraph.
Impugned order. Page number.
Page number 81.
81.
Second paragraph. However, the promotion is subject to condition that the financial benefits should be allowed to him notionally, as the petitioner did not.
No financial benefits.
My lord?
No financial benefits.
No financial. They are fixed notionally. And see the first order, my lord, at page number 48.
Go to 48.
And impugned operative part is page number 55, my lord.
What the chairman said?
Accordingly, we direct the state respondents to refix the seniority of the applicant from the date of initial appointment, that is 1/10/1982, and grant him consequential service and financial benefits.
Okay.
Applicant will be eligible for consideration of his placement in the gradation list, Annexure 4.
Is accordingly disposed of.
My lord. After that, they have promoted the petitioner on 12/12/2017, my lord.
12/12/2017.
17, page number 65. Order has been passed on 9/1. Order has been passed on 19/12/2014.
11/12/2017.
17. They have complied the order on 12/12/17.
Your grievance is against notional benefit. That benefit ought to have been given to you.
My lord.
That is the grievance.
My lord. Instead of paying regular salary from 12/12/24.
They have denied that to you.
My lord, they have denied.
That your grievance. They could not have denied is your version because of chairman's order.
My lord.
OA order.
My lord.
Take a notice. State council. What is standing council?
Additional standing.
Additional standing council, Shri, requested to accept notice for the respondent, all respondents,
Minor.
officials.
My lord, specifically opposite party number 3, my lord, 3 or 4.
All right. All responding. All after 4 weeks for filing of counter. Hopeless, if any.
Item PPP.
May it please the Lordship.
Yes, sister.
IA has been filed 3478 for correction of the cost title of the writ petition. The addresses were
Correction of the cost title.
Yes.
Yes, is still disposed of or pending?
It
is still pending.
The writ petition, the issue notice, the order has been passed for issuance of notice. So when the notice were being issued, the addresses were incorrect. So IA has been filed for correction of the cost title. So the proper addresses would be incorporated and then the notices would be issued.
Learned counsel for the petitioner submits that an application is moved supported by an affidavit seeking rectification in the cost title as to the addresses of certain parties. And application needs to be allowed in as much as coordinate bench of this court has already issued notice. First up, I agree. Next.
When notice has not been issued?
They want to, whether notice is issued or notice is issued now.
No notice is not issued.
Notice is issued.
Notice was supposed to be issued on the order dated 2024-25. Then the addresses were incorrect, so the court ordered for a rectification of the cost title.
Submits that the notice was to be issued by the coordinate bench, and at that stage the defects were noticed in the cost table, and therefore application needs to be allowed. I agree. Next paragraph. In view of the above, application having been favored, leave is accorded to effect the amendment to the cost title as sought for in the application.
Obliged.
That then we'll issue notice to.
Obliged.
If a rectification is made within 1 week, issue notice to the respondent. So who you appear for whom?
For state.
Only state. Who are
respondents?
Who are the official respondents? Whom you represent?
Official respondent.
Who are they?
OP number 1, 2, 3, 4, 1, 2, 3, 4. And 5, 6 are private respondents.
Issue emergent notice to private respondents, returnable within 4 weeks. 4 weeks. Requisites within 1 week.
Item 52.
Yes, sir.
I am for the Kendriya Vidyalaya Sangathan. He is not made party, though I have filed. He is not made party to the Kendriya
Impleading application you have paid. Is it impleading application?
Impleading, no. Not impleaded. I have Union of India is from a party. He has made the opposite party one as a Union of India. But they wanted the admission in standard one in 2021-22 academic sessions. Now in the meantime, 4 academic sessions already been over. And the matter ultimately already infectious.
Petition has become infectious. Learned counsel for the petitioner submits.
No, I am not the petitioner. I am from Kendriya Vidyalaya. But he has not made party to Kendriya Vidyalaya Sangathan. I have also filed my entire counter and he has not till date he has not made party to the case. Union of India is a party. He has made Union of India only party and state government as a party. And he is the autonomous body. KBS is the autonomous as your lordship deals in other cases. But matter ultimately infectious. Petition counsel is not present.
Matter has already become influential. It is applied for standard 1. Now it is standard 4.
So because of lapse of academic years.
Yes, my lord.
Learned standing counsel appearing for the official respondents. As also the counsel who has moved the application seeking impleadment.
Not the application seeking made, but I have filed the details counter because Union of India has signed a letter to the head of Deputy Commissioner KBS and Commissioner to the KBS.
No, you appear for whom?
I am for the Kendra Vidyasangha, Hrishikesh Tripathi, as on behalf of Kendra Vidyasangha, but it's not made party. But
Without you being a party,
that is the
how we should be heard in the matter. Where is your locus standi?
Exactly. But the Union of India has sent.
Union of India may say 100 odd things. Just I mentioned.
Exactly.
Learned Standing Counsel for the State submits that this matter had become infructuous in as much as too many academic years have already passed over. First of all, learned Standing Counsel, learned panel council appearing for the Kendriya Vidyalaya Sangatana.
Hrishikesh Tripathi.
Okay, so Sri Hrishikesh Tripathi submits that, though his client is not a party,
but filed the details counter.
He also should be permitted to agree with the contention of the Standing Counsel appearing for the state. First one. Next paragraph. There is nobody to controvert the contention of these learned counsel, from the side of petitioner. You are for petitioner, sir?
No, not the
petitioner. Next paragraph. In view of the above, petition is disposed of as having become infructuous, reserving liberty to the petitioner to seek its revival in the event assertion of the above assertion is not proven.
And this is also second round litigation.
No, of course.
Item 53. May I please, Your Lordship?
Yes, sir.
My Lord, this is the second round of litigation. The petitioner has entered into government service on 19/6/2027 to 2007.
19/6/2007.
19/6/2007. As a computer teacher cum data entry operator on contractual basis in Government High School Unity on Bhubaneswar.
What is your grievance now? What's your complaint?
My complaint is during the COVID period, all teachers continued. I didn't continue. After serving 15 years service, instead of recognizing my service after completion of 6 years service, but they have not regularized my service in spite of a direction from this Honorable Court in the previous writ petition, and they have rejected it, and I am challenging that. No counter has been filed in that case till date.
There are no counter is filed in this matter. Brother, this is of 2023.
But counter has already been filed, my Lord.
Saying
no counter, sorry, ma'am.
Let me give copy, share a copy with me.
I'll serve a copy.
Let it come in a specific date.
Yeah, receive that. All this matter of the clearance. In the meanwhile, the Standing Counsel shall serve a copy of the counter on the learned counsel appearing for the petitioner. When the counter is filed, sir?
On 27.
Look into whether
9/1/24.
Just look into whether.
Sorry, my Lord, this is not counter. This is a draft counter. Not counter.
Yes, okay. Call this matter after 2 weeks for filing the counter, if any.
Draft counter.
Finally. First up. If not filed, the right to file one stands forfeited, since this is a matter of 2023. First up. The filing of the counter should be preceded by service of a copy of the counter on learned counsel appearing for the petitioner.
Item people kindly listed to a particular date.
After 2 weeks, let it come. If it does not come, you may move a memo. Then we will.
Item 54.
Please to your Lordship, in this case, we have counter already filed, my Lord. I have also filed the rejoinder, but I have received some document from my client yesterday. So I have to file the.
What you want? Time.
I want some time.
I will give you. If you say that as a first step. Okay.
1 week time.
4 weeks. At the request of learned counsel appearing for the petition. Yes, sir.
Item 55.
No, please, Lordship.
Despite repeated orders, counter is not there.
This case I seek forthwith which time counter.
9 days they have taken.
20 matter. 23 matter.
23 matter.
Give them 2
Last chance.
Last chance. 9 to 10 days they have taken time.
As a last chance, a period of 2 weeks is granted to file the counter if any, filling which right to file one stands for 15. Because this matter after 2 weeks. The other matters, removed at 25 it will be.
Your Lordship.
At least 24 it will be, huh?
Your Lordship.
It is 25, February 25. So admittedly you have not done it in time.
Your Lordship, after the issuance of work order, another permission was given by the electricity department for shifting of 11 kV Kheranga feeder in favor of the petitioner, Your Lordship, on 12/3/2025. After this permission was given, we started the construction.
1 second. 12/3/2025,
Your Lordship.
25.
Necessary permission was given for sanction of estimate for shifting of 11 kV feeder in favor of
when it was shifted. When it was shifted.
On permission was given on 12/3/2025, Your Lordship.
It was shifted on?
Your Lordship, it was shifted on 21 March 2025 after we have deposited the
money,
Your Lordship. 21 March 2025, Your Lordship.
The 20 days which is mentioned, it should be reckoned from which date? 20 days period, which has been prescribed by the authority to accomplish the work contract.
Your Lordship.
That is to be reckoned from which date?
After, Your Lordship, in the work order, there has not been any mention.
Correct. Therefore, in the totality of the circumstances, we have to fix a date. According to you, which date?
Your Lordship, may I place some facts which have happened here? We have completed, the substantial portion has been completed. Now the block development officer is restraining us to construct the building on
restraining you from constructing the building.
Your Lordship, they are restraining me on the basis of an order passed by this honorable court, which has no connection to this case.
You are not a party to that.
I was not a party in that writ petition, and that writ petition has no connection to the present writ petition, Your Lordship, because that writ petition was filed for stopping of construction of Anganwadi center at Bhuiburuti Gram Panchayat. Not this Gram Panchayat. No, Your Lordship. So the BTO, by misquoting that order, is now
understood. Why the court restrained further construction in respect of structures in that Gram Panchayat jurisdictional area?
Your Lordship, in that writ petition, Your Lordship, I have also annexed the copy of the writ petition.
We are asking you.
Your Lordship.
You answer the question. If I doubt, then you can show. I
Your
don't
Lordship.
doubt generally lawyers. I go by version of the lawyers.
Your Lordship, in that writ petition a plea was raised by a stranger that the land over which the building is being constructed was gifted by my father to some another knight. Your Lordship.
It was a contentious construction.
And that contention was not correct, Your Lordship, because the gift deed was executed by some other person, Your Lordship, not the petitioner in that writ petition. And the writ petition was filed for restraining construction at Bhumibhuti Gram Panchayat, Your Lordship. So
that understood. The construction was restrained because of the dispute relating to ownership of the land.
Your Lordship. And
then why court, after coming to know?
Your Lordship, the real fact was never presented before the court. The BDO gave an undertaking before the court that I will try to explore the possibilities of relocating the Anganwadi center to some other location in the said village, and accordingly he will construct new Anganwadi center on the new location.
A general direction was not given of construction.
No, Your Lordship.
Number one. Is there any dispute relating to the site?
No, Your Lordship.
Construction is going on.
Your Lordship, the Anganwadi center, an old Anganwadi center was operating over the exact piece of land since 2004, Your Lordship. Now, government in the year 2019 released a notification that primacy will be given for construction of new Anganwadi center to inside the premises of a primary school, Your Lordship. And already since 2004, that Anganwadi center was operating inside the premises of the primary school. So there is no dispute.
Brother, why are you stopping construction? Any illegality, anything reported?
The state government's guideline is the construction should be in the school premises, my lord. The private school premises. Other than school premises, my lord.
But the construction is halfway through. Half of the construction is over.
Yes, my lord. It is
you should have thought it before.
Right, my lord.
Okay, you will stop construction. You let him complete the construction without prejudice to your contentions in the writ petition. Suppose in the event writ petition fails, then you are protected. In the event writ petition is allowed, you have to make payment for that construction also. Because you permitted. He did not come on his own to put up construction.
Permitted was to have some land has been provided for construction.
That construction is not going on in the provided land.
That is maybe private land, my lord.
No,
not in the school premises.
Your Lordship,
the guidelines are in the two school premises, my lord.
Where did you say that construction should be put up? There was the standing the transformer, power transformer. You wanted that to be shifted. He remitted money and got it shifted.
That I have
then construction,
my lord. I have to take the instruction, my lord. In all the what my lord is pouring, my lord, all the information.
You have been stopped from putting up construction.
Your Lordship, since after 27/3/2025, since
then wait for a few days, nothing will happen.
Your Lordship,
issue emergent notice. Learned standing counsel on request accepts notice for the official respondent. Any private respondent is there?
No, Your Lordship, only Your Lordship, one letter only I will bring to Your Lordship's notice.
What for? Whoever issuing notice?
They have accepted that it is the construction is taking place within the school premises, Your Lordship.
No, next week only. We'll have this matter next week.
Your Lordship.
Have this matter next week because of the urgency involved and the possible lashing of rates that may affect the ongoing construction if stopped midway.
I come to second
instead of if stopped, that is stopped midway. That is allegedly stopped midway. Okay.
Secondly, flashing to
yes, sir. 2013 method.
My lord, on behalf of Mr. S.B. Jana, my lord, we will file a memo for withdrawal of the writ petition.
Permit you withdrawal now.
My lord.
On your submission, give a memo.
My lord, in course, my lord, I will give. I do not have the power, my lord, in this case.
Who has to give power?
My lord, my senior Mr. Sasibhushan Jana.
He said that on behalf, on instruction of your senior, you are withdrawing.
My lord, my lord.
Sri, so and so, appearing on instructions of his senior colleague, who is an advocate, who is the advocate on record, appearing for the petitioner, seeks leave of the court to withdraw the petition. Do you have objections?
Yes, my lord. No, I don't have. I am for contemptible of
On being asked, learned advocates appearing for the other side signify their consent for the grant of leave. First, next paragraph. In view of the above, this petition is disposed of as having been withdrawn with no liberty to litigate on the same cause of action. First off. File a memo. He has also filed a memo making that question. So, short memo in good English. Yes.
One thing. Sambalpur development.
Yes. Three.
I am for the opposite party, Sambalpur Development Authority.
What is the case? Where is your friend?
Not there.
20 matter.
Yes, service benefits. Service benefits.
Service benefit. Why service benefits are written?
Well, my friend is the answering party.
You are the answering party.
Yeah, but he said that he was serving under the Sambalpur Development Authority, claiming some benefits. I think you have to purchase the file. That is the problem.
You have filed the objection.
No, I think I don't have that file.
You don't have file. This is a 2020 matter. Though advocate is not ready, he is not present. We can't deny relief to the worthy litigant on the ground that his counsel is absent. Counsel is there to assist the court, not to ensure dismissal of the case. Call this matter next week, this old matter next week, to enable counsel for the petitioner to come and argue.
Item 4.
Yes, sir.
Item 4.
Who for the petitioner? Because this is old matters, your lawyers do not come here. Then how to do justice to the litigant?
Rangadhar Bera has been passed away since long.
Passed away.
Possibly associate must have been missed release or something else. We can implement them.
Reported at the bar that the learned counsel appearing for the petitioner, Sri so and so
Rangadhar Bera
has passed away. First up. Next one. View of the above, issue emergent court notice to the petitioner. Next.
Item 5.
Yes, brother. 5. Who appears for the petitioner? None appears for the. What is the matter, brother?
My lords, in fact, this is Jagannath Temple has its own lawyers. We don't represent.
Okay. Well, who appears for temple? Panel advocates are there?
My lords.
Panel advocates are there.
Mr. Anand Swami is now appearing. Your lordship may indicate his name so that Anand Chandra Swami.
Ananda
Chandra Swami.
Ananda Swami. Learned panel counsel is requested to appear for the temple, being the panel counsel. See, so being the panel counsel, he is requested to appear for the respondent temple. First, court notes the absence of counsel appearing for the petitioner as well. First off, call next week. Yes.
Item C.
My lords, here also, the Berhampur Development Authority is the answering party.
Who appears for the authority? Any panel council they have got?
Berhampur Development.
Panel council.
Panel council. Anybody, can you, do you know anybody? You should have list of names of all panel council, central government lawyer and government advocate.
My lords, this matter can go to mediation, my lord.
Mediation.
Because this is complaining illegal constructions, unauthorized constructions, that can be sorted out.
Right. Matter essentially relates to alleged illegal construction of a structure. First of all. Yeah, you appear for whom?
State.
The additional standing counsel, Shri AGA, Shri so appearing for the state, agrees with the suggestion of this court that the matter can be sent for mediation to work out settlement. That will be first off, in view of the above. And counsel for the petitioner is absent. First off, in view of the above, matter is parties are directed to mediation. With center, any center is here.
Yes, my lord. So mediation center.
Mediation, at what is it called?
That is arbitration and mediation center.
At arbitration and mediation center.
High Court arbitration.
High Court arbitration and mediation center. Cuttack.
Yes.
Cuttack.
Near Judicial Academy.
Cuttack. Parties through their advocates are put to notice to appear before the mediator on some date you can fix. 18th of August 2025 and seek instructions at his hand. Further instructions at his hand. First off, mediation process to be accomplished within 4 weeks from the date the parties appear. Okay.
Item 7.
Seven. What is this matter? 2015 matter, 10-year-old matter, party lawyers are not coming. Why I am so liberal to all of you? Why should not they come and argue? If they make out a case straight away, I grant the relief. You appear for the state government.
My lord.
What is the matter?
My lord, a fake certificate, caste certificate was issued and that was recalled by the Tahsil.
Fake was issued. How can fake be issued? Issued wrongly or?
Wrongly.
Wrongly. Okay. So that was recalled. That is challenged.
My lord.
But counsel for the petitioner is absent. This matter pertains to the downtrodden class. Counsel for the petitioner is absent in this 10-year-old matter. Registry to send emergent notice to the petitioner to make alternate arrangement for representation immediately. Call on 13/8. How, if lawyers are absent, how courts treat that absence? referred to mediation. Parties to appear before the mediator so and so at the center at 11 a.m. In that matter was also fixed time, and seek further instructions at the hands of the assigned mediator. First of mediation to be accomplished within 6 weeks. 6 weeks. Okay, next.
Item 8.
Item 8, my lord. I need some time to seek instructions. Both the matters will come together. It will be easier, my lord. To
If we send this matter for mediation, can't I send that matter also for
This
mediation?
is in respect of the building plan of the
My lord.
BDA authority.
that has been revoked.
Mediate.
So
My lord, I have to seek instructions from my client. That's all.
there is a provision of amnesty scheme also. Some of the things construction can be compoundable.
When do you want this matter?
Next week.
Well,
I'll
then
seek
we should-
instructions within that time.
Call this matter next week at the request of the net counsel appearing for the petitioner.
Also,
To confer with her client.
Can I request, my lord, the other writ petition maybe also be tagged?
Along with the first stop, along with WP number
27554 of 2019.
27554 of 2019.
My lord.
Okay.
Item 9.
Yes.
The order passed by the.
Can you refer to mediation?
It cannot be because my lord, the state level scrutiny committee.
That is that SLBC
Order in
Hon'Ble
challenge.
judgment of 95.
Yes,
State of Maharashtra.
Yes.
90.
That is 95 94 94.
Okay. So it cannot be a matter of mediation at
No,
all.
it cannot. That is why.
It is submitted at the bar, and this court agrees with it that the subject matter relates to the social status of the petitioner. And therefore, it cannot be subject matter of mediation. More particularly, in view of the observations made by the apex court in Madhuri Patil versus State of Maharashtra, 1995, Supreme Court, 94.
Page 94.
94. Yes, AR 95, Supreme Court, page 90. But list this matter next week in regular list.
10 days after also.
10 days, after 2 weeks in regular list. Okay.
Item 10.
May I please, your lordship?
Interim order, if finished, continue for a period of only 10 days.
Item 10.
May I please, your lordship? Lordship, I need some time to obtain instruction in this regard, your lordship. This is a 2015 matter, your lordship. I have to obtain instruction.
What instruction? We are not cross-examining anybody.
No, your lordship. This is a matter of B.Ed exam, your lordship. In the meantime, any changes should be made in the scenario should be changed. So I have to obtain instruction, your lordship.
On this matter, on Monday, at the request of learned counsel appearing for the petitioner, finally, since matter is more than 10-year-old.
I am for the opposite part number 1.
In the previous matter, your lordship extended the interim order 10 days.
Next date of hearing.
Yes,
So this on so and so. Only till next date of hearing. Yes, otherwise it will never come with
Item-
interim orders. Okay.
Item 11.
On behalf of Mr. K.K. Rao, my lord, no instruction from the petitioner.
No instructions.
No.
Then you have to argue the matter based on papers. Why instructions? And you have already filed the writ petition. If they are filed objections, look into them. If no objections are filed, you argue the matter. Any apprehension about the court, that court may not grant relief to you. You don't want to speak?
Yes, ma'am.
What's your name?
Smriti Rekha Sahu.
Miss so-and-so seeks a short accommodation on the ground that file is misplaced. Full stop. Call this matter on Tuesday. Tuesday next. Finally, you can take the file also from the court. The registry to furnish a photostat copy of the file at the cost of the petitioner if request is made. Okay.
Item 12.
Well, application papers. Okay. This is also 2016 matter. What is this matter about? We'll say refer to mediation.
This can be.
Happens, otherwise not.
This can be sent to the mediation.
Refer to mediation. And put some date, same format of the orders. We change some date, another date. Yes.
Item 13.
13.
This can also mediation.
Yes.
LIG housing allotment scheme under the Jharsuguda.
Some date. Yes.
Item 14.
May I please, Your Lordship, my lord, I am appearing on behalf of Union of India, opposite party number 1 and 2. Copy not shoved to us, my lord.
Huh?
My lord, the copy of the repetition not shoved to us.
You are saying it after 9 years.
My lord, the matter is coming up after 9 years.
It did not come at all, see the light of the day any time before.
It was last listed in the year 2016. I have got instruction to appear in this case just day before yesterday.
Yes, Mr. Mohan.
About waiver of that scheme under the debt relief scheme in the agricultural scheme loan.
Okay.
This can also be mediated by that whether the scheme provides as such, then this can be done.
Done.
Because this is a scheme.
Correct.
If it will come under the
mediation.
Exactly.
Refer to mediation.
My lord, my appearance may kindly be recorded, my lord.
Sri so-and-so appears for the Union of India.
Yes, my lord. Opposite but now 1 and 2.
1 and 2.
The agricultural debt.
Therefore, it can be a matter
This
of...
can be mediated.
Name of Sri CK?
CK Monty, my lord. CGC, Central Government Council.
Item 15.
15.
My lord, I am appearing on my behalf of senior. May I make a submission? Sir, I am for the petitioner and the cause of action does not survive as the grievance has been readdressed by the opposite party.
Addressed by the opposite party?
Yes, sir. And the payment has been made.
Learned counsel, Miss so-and-so, appearing for counsel on record on instructions, submits that the writ petition having become infructuous may be disposed of accordingly. First time. Do you have any objection? No. Then the additional standing counsel, Sri so-and-so, says that it does not dispute this position. First time. In view of the above, petition is disposed of as having become infructuous. Okay, so file a memo also.
Yes, sir. File in the course of day.
The memo is also filed. Now only, not for
Okay, sir, now.
Yes.
Obliged, my lord.
Item 16.
16, my lord, batch of cases.
Of cases argued.
My lord, I pray for in my cases, it will mediation center may be sent, my lord.
All these cases can be sent to me.
No, my lord, my case is some cases I am giving the list, my lord. That case may be sent to them.
In all these cases, you appear.
No, my lord.
Other counsel also appear.
Other counsels are appearing, but they are not coming.
They are not coming because
WPC 6410/2018.
WP
Number 6410/2018. That can be disposed of here, madam.
We can dispose of here only.
Yes, ma'am.
What is that matter?
They require some amount, and we have already indicated their counter that the concerned party was also directed by NTPC madam to clear the amount. Because it's a work of NTPC Limited done by a contractor. And we have given them instructions. If at all anything is to be payable, madam, it will be payable by the contractor.
No, sir, this not his case separate. I was working as a subcontractor under the power grid.
Worked out in mediation, na?
My lord.
We'll refer all these matters to mediation.
That's cannot say other counsels are there. I cannot say about them.
No, court. We have put all the advocates, world clerks to notice. by virtue of this list. They are not opposing.
Lordship,
See, also taking individual cases, or we can find the send them to mediation. Same, all matters.
My appearance will be noted, my lord, in 6410. I am for NTPC Limited. 6410 2018. Respondent number 2, 3, and 8.
Kindly spell your name.
B.S. Tripathi, my lord, senior counsel.
Yes, Tripathi. Your senior counsel. Can you appear like that without an advocate on record?
No, my associate is there. Mr. Amit Sahu is there.
Advocate. Tripathi appear for counsel on record for the petitioner. Oh, one sentence you can. You can also mention name also. W.
6410.
Refer to
2018.
Yes. Yes. It's not going to should not be big question the mediation.
Item 17. Item 17, my lord, the petitioner has already expired.
Petitioner has expired when?
My lord, since 2-3 years back.
2-3 years. You are the counsel for the petitioner.
I am the counsel for the petitioner.
Learned. So what we will dispose of this matter having statutorily abated because no LRs are brought on record.
Yes, my lord. No, LRs cannot also prosecute this.
They cannot prosecute.
No, because there is a dispute between the husband and wife, my lord. There are two brothers. This is a very interesting case, my lord. Two brothers. The elder brother name is Pradyumna. He is working in Indian Army in the name of Prasanna, his younger brother. It's a case of fraud, my lord. The elder brother, although his name is Pradyumna, he is working in Indian Army in the name of Prasanna, his old younger brother. And Prasanna, who is the younger brother, he is serving in my lord, police, my lord, in the name of his elder brother. This is the fraud they have committed. It's a very serious matter. And in the meantime, of course, he has been convicted. My husband has been convicted under section 490 to 420. And he has already there.
He jailed.
Yes. Here I had prayed for the
of the individual.
No. I have prayed to initiate a departmental proceeding against my husband, my lord.
Now that question will not arise.
That question will not arise because he has been convicted and his services are already gone.
Learned counsel for the petitioner submits that the petitioner having died, the cause of action does not survive for prosecuting this petition. This assertion of the counsel is not repelled by the other side. First, next, in view of the above, petition is disposed of as having become infructuous. Yeah. Infructuous. Very good. Yes.
Item 18.
My pleasure, Lordship.
Yes.
The petitioner is a slum dweller and he is a beneficiary under the slum development program initiated by the government, my lord.
No, this is posted for mediation.
Yes, your lordship.
Do you agree for mediation or do not agree for the mediation? Only that is the answer.
But in this case, notice has already been issued to the opposite parties. They have to file their counter.
No, if they agree for mediation.
I am appearing for Bhubaneswar Development Authority, my lords. Thing is that he says his case is that he is in occupation of a particular piece of land. Her husband was in occupation and continuously she was also in occupation of that land. It should be settled in her favor. The ownership of the land lies with my lord's GA department.
Your claim.
No, government is GA department. General Administration Department. In Bhubaneswar, my lords, all these lands are being taken care of by General Administration. It is the owner. So, my lords, if she claims a title over that property, so either she has to approach to the GA department or she has to go for a declaration under the suit.
So, we have to hear this matter. It cannot be subject matter of mediation because public property.
Yes, my lords, public property is involved.
that particular area, my lords, most of the areas, my lords, now it is being taken up. A slum dwelling scheme is being developed there.
Learned panel, senior advocate appearing for the
Bhubaneswar Development Authority,
my lords,
along with Mr. A. Das.
Along with Mr. A. Das, advocate on record for the petitioners, advocate on record for the authority, submits that the subject matter of this petition is not mediatable. What is the word that is not fit for mediation? That fit for mediation. Or it does not. The matter does not admit mediation. Public property having been involved therein. First time. Registry to post this matter for hearing next week. Push this matter next week.
So, may I pray, my lords, in the meanwhile, my lords, let government take a step as counter and all these things so that it can be taken off at once and can be disposed of.
2 weeks. In the meanwhile, it is open to the intending parties to file their pleadings, if any. Failing which, the right to file one stands forfeited. Yes.
Item 19.
Yes, brother.
For admission to class 6 in 18, might have been infructuous. So
it has become infructuous. Academic matter.
Yes.
The learned counsel, Mr. Dash, appearing for the petitioner, in all fairness, petitioners, in all fairness, submits the petition involving the academics has become infructuous by passage of time, and therefore we disposed of accordingly. First, learned state counsel, standing counsel appearing for the state does not dispute this. Next paragraph, in those circumstances, matter is disposed of as having become infructuous.
Item 20.
Issuance of green card having 2 children. Issuance of green card having 2 children. Notice has been given, no counter has been filed on 13/7/2021.
Is it fit for a mediation?
My lord.
Can be mediated. Yes, and for mediation format, some date. Okay. Shri, so in so appears for the first one.
Item 21.
Mishra. No.
It has come for referral, but your lordship can decide within a minute.
Is it?
Within a minute.
It's a double alert.
But if I am as fast as you, perhaps yes, but I am not.
Double allotment allegation. Initially, one allotment plot was allotted. Then he wanted to surrender. He was applied for another plot, granted. He invested all money since last 25 years. Constructed his house, is residing there. Now, after 25 years, notice has come. You have taken double allotment, you surrender.
Whether double allotment is taken or not?
Yes, surrender the latter one. Where I have invested.
Yeah, but for all right, you surrender the first one.
Exactly.
You can't retain 2.
I have said that you take it.
First one.
No, why first one?
So, in fact,
surrender, Apex court said, Allahabad High Court said, where a person is wrongly granted 2 sites, and on one of them he develops, in one of them he develops. You can't say he should surrender the development.
Right, my lords, that I'm aware also. But fact, the background is something different, my lords, here in this case, particularly Bhubaneswar and Bhubaneswar Development Authority, Cuttack Development Authority, General Administration Department, Housing Board. What these people have done is, they filed affidavit and got one allotment that I don't have any plot. Subsequently, they filed, suppressing that, subsequently they filed affidavit and got allotments. So what happened? Multiple allotment under discretionary quotas of the Honorable Minister.
So fraud on the system.
No. But this is not the position. Then it was taken up by the government. A committee was constituted, headed by Tara Datta, Additional Chief Secretary. This is called Task Force Report. That Task Force Report reported that a person concerned, those who are availing multiple allotment,
the proceedings must be initiated against them. Now question is, these are being dealt with under the resolution of the General Administration Department, because General Administration Department is the original owner in respect of those plots. General Administration Department directed the Bhubaneswar Development, all other development authority proceedings are going on in case of number of cases. But here in this case, what happened? 2 plots. Now what my lord says is correct. This would be the proposition. Also I do agree, but fact remains it is the GA department who has to clarify and give that permission to us, so that we can consider, suppose two or three, whatever matter may be. Which one you will give an option, which one you want to prefer, keep it, the other 2 you refund and return. That GA department is to clarify. That is the problem.
One second.
Give one sentence.
Is there a fraud
No.
in getting 2 sites?
No, sir. That is exactly my case.
But then, my lords, it may be placed, my lords, I have already filed counter, links are ready, maybe any day may be taken up, so that it will be hard. In the meanwhile, GA department also may take instruction.
Yes,
it can be placed and hard. If my lords will decide that on principle, I am conscious of the Allah judgment.
The matter is simple, reason being. Well, 2 plots are there. I have given a letter way back in 2009.
That we denied, we have not received that plot.
99. That you take the plot. I have annexed the document. Now I applied for another plot. They granted me because they have to verify and grant me. They granted me. And I invested money on that.
No, after having written that letter.
Yes.
What happened to the fate of the letter?
Sir, I have, so they said you apply first, I applied and they
where was said that?
I'll show that.
Yes.
One thing I would like to clarify at this stage. Well, because I'm not ready on the human.
But it's all right.
What is one sentence, but the task force report is not the law.
It's a report.
It's a report.
It's a report. On the basis of which, unless you amend the law, you cannot take the plot. I may be convicted for filing a false affidavit. Maybe if at all I have filed, but the land cannot be taken away. Now they are trying to cancel.
With due humility, my lords.
Sir,
that may not be the correct position. There are English judgments.
Sir,
cancellation. I will let me tell you. There are English judgments where such an argument was made. That was a case where a person took bribes and he said, you can convict me for the offense of bribery, but you cannot take the money of bribe from me. The English courts usually common.
Usually, this procedure goes on so far confiscation is concerned, first act and other act also.
Here, question is a little bit different. With due respect, you give an example, that's right, correct, but that's a law article will say. Here, the person never files any false affidavit.
That is the thing.
The person has not filed any false affidavit. They say it's a double allotment.
Which is not permissible under the policy.
Not permissible under law, right? That was on the basis of the task force report. That was on the basis of task force report. So prior to that, they have never issued.
There was no law. Which saying that one cannot have more than one
section. Department itself allots more than one plot.
That is what this task force was supposed to prepare.
Department itself allots more than.
But Mr. says, unless law prohibits allotment,
with due respect to my lord and my lord.
What is the status of task force?
Well, task force that is on force and operation. Cabinet has approved it.
No, cabinet under what power?
Thereafter, let us not take the task force account. But fact remains, my lords, not just a minute. Fact remains, my lords, here in this case, before allotment, you have to give an affidavit as per the terms of the brochure. The brochure, you have to say that yes, you don't have any plot within such and such area. Yes, that you have given that affidavit.
Has he given that affidavit?
Yes, my lord.
Show that.
That is there.
For a moment. For a moment, just.
So can you look at page 55 of document?
No, Mr. Panel Counsel is saying, Mr. Shripad is saying.
Mr. Mr. Dhananand.
Okay, I'm sorry, I'm not that familiar. That's here.
My lords,
yes.
My lords, kindly have a glance to Annex A by 4. A by 4 page 10 to my counter.
Affidavit is given.
My lords, this affidavit. Yes, 2099, class 2. That is what I say.
Any of minor children do not own, possess any residential right house flat in the jurisdiction of municipal corporation area, Bhubaneswar. This is given.
Why say bank like
This is given, sir.
Yes.
I said I have given, sir.
Because on that ground they have allotted.
So on that ground they have allotted, but here trying to see the document, A6.
Yes.
I have not manufactured a document.
No, may I submit? I shouldn't spoil my precious judicial time. In my learning, brother will mention the agreements, then we can take over the matter for a final hearing so that can we
Call this matter day after tomorrow. We'll finish off the matter.
Day after tomorrow, another matter. Any day, next week, any day, my lord.
Any day, we choose any day.
Any day, we choose my
Mr. Mishra.
My senior will be busy in a number of places. The day you agree.
Anyway, some humor is required in the court hall also. Yes.
6th or 7th the detail.
8.
Item 22.
This date is chosen by both the sides on their own.
Yes.
And therefore, any motion for adjournment shall not be entertained.
Yes. So the interim order is there.
Interim order to continue till next date of hearing.
And here should also keep it in mind that I am ready to surrender. I am ready from 99 till now.
That is so.
Suppose if the thief gives back the stolen goods, whether the theft will come to an end.
But the question is, with respect, if it has been done, it has been done 99. You kept quiet for 25 years. I borrowed money, I have taken loan, I have my all savings, my retirement benefit, everything I have invested in the property. Now after 25 years, can you say now you have committed a fraud and surrender?
That so far equity ground is concerned. So far equity ground, I want to this is submission. This is a submission is concerning equitable ground. That is what the DGA department is to give us that scope. To choose in such a constraint and such a contingency whether we will exercise the equity or not, because that discretion is not with me, not with this authority.
I'll be in the street.
I am aware that.
Just consult your official clients, because Mr. Mishra is saying, I am ready to give back the first site.
Right.
Because everything, whatever we are doing, is on the resolution of the DGA department.
I am not in position.
No, but earlier, my lords, in another contest, some dispute arose. Because of the GA department proceeded, then Honorable Court directed to file an affidavit. GA department filed it and clarified 290 number of the cases my lords got disposed of. So if GA department clarifies this, I think the problem will solve not only in the particular case, but in many cases.
Other judges of this court have treated with your submission of the kind.
In fact, can I just say, one of the judges who suggested the matter was taken over hearing. He said, you take instruction, he is ready to give. So why not take
that is what thereafter
any decisions. Asking for the rulings of the.
No, it is awaiting
just discussion.
No, it is awaiting my lord's decision.
That decision, one of the decisions is that the task force report cannot be a law and stay has been granted by this Honorable.
No, we agree. Report cannot be a law at all. Report is a fact-finding body, maybe recommendation to the government to come out with a policy, etc. That is all right. But there are other invariably my lords are appearing for Mediation and other authorities.
One decision also.
Don't want the problem. The problem.
Your party. Vishwakarth has already passed on. Exactly on this point. Considering the contents of the petition and submissions, Mahapatra is in council now. The government authority, they're voting one plot. There is foregoing of one plot involving multiple allotment.
But no law is discussed.
That is exactly my
no law is discussed in this. So this is only fact. This is a case-specific judgment.
Once it is awaiting my lords with due humility, I submit my lords. So far DDA is concerned, I am appearing, and Housing Board also I am appearing. No case, no law has been let down till date. It is awaiting my lords.
Since they must have acted upon.
Good. Question. ଆପଣ ଭଲ ରାସ୍ତାରେ ଅଛନ୍ତି, you are in a good side. Equity greens in your favor.
So he says that.
I'm appearing by the authority. But I all along should see that yes, equity should prevail, or else see that injustice should not be done.
But equity means equity
To the
a person who is scrupulous.
yes, man. Unscrupulous, filing false affidavit, committing fraud. These are all exceptions to that.
Let us.
Item 22. Item 22.
Can we refer to mediation?
No, my lord, arguing counsel is not well, so I think it's not urgent.
You want to argue the matter?
No, adjournment. It's not
You want
urgent.
adjournment of matter?
1 week.
Counsel for the petitioner says matter should not be sent to mediation. And therefore I cannot post mediation. First of post before the court, week after next. Yes.
Item 23.
Refer to mediation. Say for the some detail of things. Yes.
Item 24.
Yes, sister.
My lord, kindly adjourn this matter for next week.
Next week.
Yes, my lord.
Cannot be mediated.
Yes.
It's a matter for mediation.
Yes, you
Can
can
you send for mediation?
Yes, my lord. Oblige, my lord.
Srimati, so and so, we have solved the suit. Refer to mediation. Okay.
Item 25.
25 minutes, which is to be decided. Yes, madam. It is a interstate dispute. It cannot decide it in the mediation. It cannot. But I am ready also, but only problem there is some vernaculars, documents. So we have to get it translated. Otherwise, order of the State Education Tribunal is under challenge here. Wherein, my lord, the fact of the case is, my lord, but
Anyway, I cannot take this matter because they are in the list of mediation. We have no jurisdiction to decide as such.
yes. So can it be
Counsel, Mr. Dash, appearing for the petitioner submits that matter need not be sent for mediation. First time. In view of the above, a registry to post this matter before the court in regular list.
But there was an interim order, my lord.
Interim order to continue.
Obligement.
Item 26.
26 referred to for mediation.
Mediation. It's referred to mediation. Not a case for mediation.
Matters with the due humility, matters can be taken up. I have not available.
Next.
May I pray, matters? May I pray small prayer? Filed counter, but somewhere I missed the file. I mean, permitted to take all these on soft copy. I will through my pen write.
The learned senior advocate Sri so submits that since file is misplaced, registry be directed to furnish a soft copy.
Soft copy, generally, on permission, they are soft furnished.
Of the same if applied for. First one. Ordered accordingly.
Item 27.
For this matter, we call.
The merit visualization. My lord, here is the case, Miller. The present petitioners, Miller, they are representing the entire villagers comprising more than 2,000 of a revenue village. That resolution is there. They have approached this honorable court challenging the state government notification that has been issued by the urban development department regarding taking up the village area which is admittedly within the Gram Panchayat area Gram Panchayat jurisdiction to a development areas. That is the resolution, that is the state government notification. It has been challenged. On the first ground of challenge
is under which legislation?
That is under the Registration of Development Authorities Act. That is the Central Act, Miller.
State Act.
That is the State Act, Miller. Pursuant to that Development Authorities Act, initially that was framed in the year 1982, Miller. And pursuant to that Act, Contract Development Authorities, it was created. Then BDA was created on the same day, pursuant to this Act. And this Act, Miller, my submission is I have relied upon 3 decisions. One division bench decision of this.
For what proposition?
Miller, proposition is that notification itself is a defective one in view of section 3(2) of the Act. I will satisfy it, Miller. Then second proposition is that this honorable court in a division bench decision has categorically held that the Gram Panchayat area, these are coming under the Constitution, part 9th of the Constitution amendment by the virtue of 93 amendment. That is Constitutional Amendment 443 of the Article 443 of the Constitution. I have taken all sub ground. Then you cannot take away, the State Act cannot supersede the constitutional provision because the Gram Panchayat is not a party to that case. It was not heard, no opportunity was given to them. Then administration from the Gram Panchayat cannot be taken into consideration. One thing. Then our specific case is that the principle of natural justice, it has not at all been followed, Miller, in view of the Act itself as well as the corresponding rules. That is another point, and decision is in our favor.
So we'll fix date appears to be.
No, it can be disposed of through mediation, Miller. No, you are not.
Mediation will decide.
Miller, you will assume a kind.
Constitutional.
Miller, that Miller, principle of natural justice is also there. No notice as per the Act provision, it was served on the no scope was given to the villagers, Miller.
That's all right.
Miller, let the villagers to be before the authority, so that
not a fit case for mediation. Case for argument.
Miller, what opportunity may be given to the villagers, because so that the government officer and villagers, there is a provision also. There is a provision interaction, Miller. One opportunity should be given, Miller. I think, Miller, I don't have any.
Put this matter someday, Miller, of your convenience, Miller, so that you can argue. Choose a date of your convenience. Whichever date you say.
Any day 2 weeks after me, Lord.
Yes, kindly choose a date.
मैंने क्या बोल रहा स्वाधीनता पर क्या Your Lordship may kindly, week commencing from 25th, Your Lordship may kindly fix
call this matter on 25.
Week commencing from 25th August.
Therefore, we call it on 25 only. 25.
Yes, Miller.
This date is chosen by all the learned advocates appearing for the parties on their own, and therefore.
Let it be treated as a fatard also.
No, I have not heard that way. We cannot make false orders.
Miller, interim prayer is also there. Status quo may be.
All these, how long it has been pending with the
Miller, subject to
let us
result of
the choose a shorter date. We'll hear it dispose of.
25th date. Right.
Item 28.
Can be referred to mediation.
No, there is no mediation because municipality, for the municipalities, they are Miller. The only Miller they dispute Miller. In front of my house, there is the Miller the entire area.
You can't argue on merits because it is fixed for particular purpose, which
yes, only for Miller make application before the J department, then your Lordship problem will be solved.
When which date you want?
Miller say J department make an application before the J department.
Case for mediation, as written submitted at the bar. First off, register to post it in regular course. First off, call on. Choose a date.
As your Lordship, any day.
24 matter, na? Call on 26/8.
As your Lordship. Great. Your Lordship.
Item 5 matters I could not read while it was called.
Item 5 matters.
The matter has become infructuous matters.
It has become infructuous matters. Item 5. Learned counsel Shri so appearing for the petitioner fairly submits that matter has become infructuous and therefore accordingly it be disposed of. Next paragraph. Ordered accordingly, writ petition is disposed of. Courts having been made in forward.